fall within the...
Ezra Klein, Derek Thompson. I don't know anything about the Derek Thompson guy.
Oh yay, oh yay, oh yay. All persons having business...
Really? Oy vey? And this is supposed to be not controlled by the Jews?
before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Off topic, but do you think it'd be good for Canada to move closer to China economically with the way the relationship with the U.S. has been heading? Yeah, but you run into a big issue. So your big issue is that the U.S. is the master of, or at least conservatives are like the master stolen valor people when it comes to complaining about issues that don't really affect the United States but have huge impacts on other countries. The problem is that Canada being, I don't want to say subservient to, but like Canada relies on the United States for their economy to work. But largely speaking, that's okay because the United States is not like an evil, terrible country that's going to fuck over Canada with like crazy shit like random tariffs or trying to destroy their economy like we're doing right now, right? For as much as the United States complains about China being unfair, in my maybe slightly uneducated opinion, a lot of the unfairness from China comes from the fact that, one, it probably doesn't have a massive impact on a lot of the U.S. firms operating in China or in the United States. And two, the only reason why we haven't done a lot about it is just because of lack of political will, not because we truly are incapable of you know, wrangling anything from China in terms of concessions. This is my take on it. Canada, however, being totally reliant on China and not having the U.S. anymore in its corner could actually face a lot of what people fearmonger about China doing to the United States. China probably could do it to Canada, which would be scary because now if you're Canada, you're basically completely relying on the goodwill of a country across the Pacific who could be at ends with you for a variety of reasons. It's just a very scary world to be in, I think.
Case number 25-5067 et al. JGG et al. Versus Donald J. Trump in his official capacity as...
Unbelievable, the confirmation bias from Republicans, but then also, what is this? I don't know. All I know, Gary bad. I already know that Gary is bad because I've watched him talk about econ. I didn't know if this bad economics post was going over economic claims that he's made, but it seems like it's focusing on just his master's thesis, and it's going over with the formulas that he builds for his thesis and why the application of those formulas is flawed. The subject matter of this post is going to be incredibly dry and boring, and it's not going to have very much to do with any of the overall claims that he makes, so it's bad content for stream. I'm sorry that you're an ass-paying Gary lover, but try to find a single video of him making any actual concrete claim.
Good afternoon. May it please the court, Drew Ensign, Deputy Assistant Attorney General for the United States. The district court's order represents an unprecedented and enormous intrusion upon the powers of the executive branch. It enjoins the president's exercise of his war and foreign affairs powers under the Alien Enemies Act and does so in a manner that purports to direct operations outside the United States borders and in a manner that could intrude upon sensitive diplomatic negotiations. The basis of that order was explicit second guessing of the president's determinations that the statutory preconditions of the AEA were satisfied for a foreign terrorist organization, Tren de Aragua, or TDA. Even though both the Supreme Court and this court have explicitly held that such challenges are not within the power of the federal courts to hear. The district court's order is therefore appealable, much as a TRO directing the president to redeploy a carrier group from the South China Sea to the Persian Gulf, or to halt...
Hang on. I mean, one of the claims pressed here, which the Supreme Court has expressly said, and we have said, courts can entertain, so put aside interpretive questions about whether there's an incursion or invasion, is whether these individuals qualify under the terms of the proclamation, whether they're members of Tren de Aragua.
Yes.
I assume, as below, the government does not dispute that that is something courts can adjudicate, correct?
Thank you. Is it normal to interrupt the opening statement? I don't know what, I don't think we've ever listened to oral arguments from like a court of appeals before, But yes, please drop this stupid fucking analogy, this actual Reddit meme tier argument of are you saying that a federal court could say that we have to turn our ships around if we were in the middle of a fucking war? No, literally nobody is saying that, you fucking retard, you mongoloid. The argument is whether or not people in the United States of America have a right to challenge their designation as per this Alien Enemies Act or whatever, right? That's what this has always been about. Nobody is making that other claim that that any federal court can direct a war. Nobody's making that claim. Nobody cares about this. Nobody's arguing this. Why are you even bringing this up? Thank you.
Does not dispute that that is something courts can adjudicate, correct?
Your Honor, it's certainly something that courts have adjudicated in individual habeas claims.
That's a separate thing, but courts can do that. And so asserting a power to do that is not ordering ships to relocate.
Thank you for shooting down this dog shit fucking analogy. It's so stupid.
Waters, right? That is straight up judicial process that's allowed by the Supreme Court and circuit precedent.
They interrupt you constantly in appeals. I can barely get a word in sometimes. Okay. I didn't remember for the Supreme Court ones if they have kind of like an opening statement they make and then they do questioning. Maybe it's different for the Supreme Court versus the Court of Appeals. Or maybe I just listened to some exceptional. I don't know. Are these low-level DOJ lawyers? These people are representing the government, so these would have to be lawyers from the Department of Justice, is my understanding. I don't know who's arguing here on behalf of the government, though.
Process that's allowed by the Supreme Court and circuit precedent. I understand you have your argument then about habeas, right? But that's a procedural point. Your points about him overstepping seem to be forgetting that there is this claim, and in fact, this morning, he's limited the TROs to the likelihood of success to that prong. And so we don't need to go any further than that, correct?
No, I don't believe so, Your Honor. Because the government has taken appeals of the TRO, the district court didn't have jurisdiction to change the basis of the TRO. And so
that was one of the bases all along.
I disagree, Your Honor. The bases of that order was set forth on page 41 of the transcript from the Saturday hearing, and they were expressly limited to just those second guessing of the president's determinations the statutory preconditions of the AEA had been satisfied.
Okay, if we read the record differently, if we read it to include these claims having been pressed from the beginning and including at the hearing, they've been saying from their complaint that their clients, at least the ones that we have, the named plaintiffs and some of the other ones, are not members of Tren de Aragua and had no chance to demonstrate that when they were rushed onto airplanes and flown to El Salvador, or at risk of being rushed onto airplanes and flown out of the country. And so if we read the record that way, then we don't have to get into these other questions, correct?
No, I don't believe so, Your Honor. And
no, we don't have to, or no, I'm wrong?
You're wrong.
I guess I would say several things, Your Honor. One is that the district court's order goes well beyond merely preserving the status quo. It purports, as the district court explained, to order the president to conduct operations outside U.S. borders in a particular way.
This is such a stupid fucking argument. Or, like, do you think that federal courts lose jurisdiction just because you step outside of a U.S. border? That there's no more due process for a U.S. citizen that you've taken, or for a U.S. green card holder? Like, this is such a stupid argument. It's so fucking retarded. It's like Trump crosses into Canada with a child and rapes him, and then a federal court is like, hey, like, you know, we're charging with it or whatever bullshit, and it's like, well, hold on, actually, are you telling me that a court can somehow make declarations about events happening outside of the United States of America? No, what the fuck are you talking? Like, that's not what this is about. What the fuck?
He directed that the executive branch either turn planes around or to find another way to operate internationally.
Right, but that's, so, I mean, at this point, my understanding is that the government has been complying with the TRO. Obviously, it doesn't extend to people who are being deported on grounds independent of the proclamation. So when I say complying, that there are no planes now en route out of the country with people covered by the TRO, correct?
That's my understanding, yes,
No
sir.
planes on the ground anywhere in the world with people covered by the TRO that would have to come back.
And Your Honor, let me
Right?
first clarify.
Is that factually right?
I believe so, Your Honor, though let me clarify one thing about that, which is that the district court's order only applies to those that would be removed under the Alien Enemies Act.
Correct.
It does not apply to those that may separately have final orders of
Correct.
removal under the
Yes,
INA.
that's right.
Yeah.
I'm sorry I wasn't clear. I was trying to say that up front. That was, if there are other grounds for
Yeah.
moving them out of the country, he was quite clear, was clear again this morning, but it's been clear from the beginning, that's never been enjoined under the temporary restraining orders.
That's correct, Your Honor.
Right. So we're not talking about those. So you might have planes with people going other places because.
Yeah.
When was this? Sorry for this has to do with the Venezuelans. I keep saying Venezuelans. Fuck me. With people that were deported to El Salvador, basically. Trump had a way that he was going to do it, but then he invoked the Aliens Act in order to do it even quicker, and then arguably without due process, any kind of due process. And 5 people are named on the complaint, but it's representing all the people that have been deported without having any process or procedure to challenge if they were even part of this act. Like, if Trump wins this case, then the argument follows that the government could walk into your house and deport you, that just saying that you're part of this gang, and that's it. But there's no, even without any evidence or due process, they would just do it, and you have nothing you can say about it. Like, it's insane.
Got ordinary orders of deportation.
I think that's right. And I apologize, Your Honor. I think we're agreeing. And
Okay, no, I was clearly me not being clear enough. So clearly me not being clear. So now to clarify again, my question is, the concern about ordering planes back and forth is moot at this point. That's over and done. There's nothing we could do to address that. Nothing we could do to remedy that, even if we were to agree that that shouldn't have happened. That's a question, but it's just moot at this point.
I don't believe so, Your Honor. I think the district court understands the government to be under a continuing obligation.
Understands?
I don't believe so, Your Honor. I think the district court understands the government to be under a continuing obligation, having not turned the planes around to find some other way to return the people. I don't think the district court has interpreted its TRO as no longer being operative. And so I think that continuing aspect of it supports appellate jurisdiction here.
You read it as requiring the return of people who are no longer in U.S. custody?
Your Honor, the government does not believe that the oral pronouncements as opposed to the written one is binding. But as the district court appears to have a different view, his oral order provided for 2 ways of compliance, either turning around the planes or finding a way to return the people to the United States. The first option is no longer available, but the district court has not said that the second option is not still in force.
And much of this, I think, has to do with the compliance issues that are, I think, separate and go forward regardless of what happens with TROs. And so as of right now, your concern is that if the TROs, and well, for your sake, say even the written TRO, so the written version of the second TRO is in place, what language in that requires the retrieval of people from U.S. custody?
Your Honor, I think
Sorry, let me clarify again, that are no longer in U.S. custody?
Your Honor, it would not be the written order. I believe it's on page 43 of the Saturday transcript. It was an oral directive, but more broadly too, this is a nationwide TRO that enjoins the president from using any of his AEA authority to remove people during this period.
Okay.
That is something.
But that's different. That's not ordering ships around in the water. And that's not ordering planes to go anywhere. All that the nationwide TRO says is folks that are detained and folks can still be detained under the AEA. They just cannot be removed from the country until this point, until I guess you get a preliminary injunction decision from the court, which looks to be forthcoming soon.
I agree that the district court looks like it may be acting on a preliminary injunction soon, but I think the intrusion upon the war powers and foreign policy powers of the president is utterly unprecedented. And in a way...
Well, this is an unprecedented action.
Yes, that needs to be the answer to every single thing. Every time they say, like, it's unprecedented, no one's ever done this before. Your actions are unprecedented, sir. So, of course, our response is going to be unprecedented as well. They keep saying that. The J6 case, it's unprecedented. The New York charges, those are unprecedented. The Mar-a-Lago documents is unprecedented. Yes, your actions are unprecedented. That should be the response to every single time conservatives wield this as some sort of defense, that it's unprecedented the way your actions are unprecedented. They warrant unprecedented reactions.
Of the president is utterly unprecedented. And in a way,
Well, this is an unprecedented action as well. So of course, there's no precedent for it because no president has ever used this statute this way, which isn't to say one way or the other what it can be done, but simply to say we are in unprecedented territory. But I'm just trying to really clarify here, if you agree that, and I believe you agreed in district court, I think you agreed here, but tell me if I'm mishearing, that these folks have a right under the AEA, under precedent, to challenge their status as individuals subject to, that fall within the terms of the proclamation here. That is, I think most relevantly, whether they are members of TRO Nicaragua, although maybe they deny Venezuelan citizen status too, I don't know. But the big one that seems to be in the papers is, they said, we're not even members of this. In fact, some of us are fleeing from TRO Nicaragua. Is it your position that temporary restraining order that simply prevents removal until there's procedure and opportunity in place to address whether they even fall under the proclamation? Are you arguing that that is an unwarranted intrusion on the president's powers?
Yes, Your Honor. I think whenever a district court enjoins the president from exercising.
That's an insane statement, if I understand her correctly.
Are you arguing that
she's saying, okay, the president obviously has the right to exercise these powers, but are you seriously arguing that the right of somebody in the United States to challenge whether or not the act even applies to them, you're arguing that that due process there would infringe on the president's right or on the president's ability to deport people? And he says, yes, nobody should have any ability to challenge whether or not they're actually part of some gang that needs to be deported as per this act. Like that is an unwarranted intrusion on the president's powers?
Yes, Your Honor. I think whenever a district court enjoins the president from exercising
his military, don't say the same dumb shit,
his war and foreign policy powers on bases that are manifest error, that is absolutely the sort of irreparable harm.
So,
but like, she needs to ask the question. So if the president goes into your house today and takes your child from you and puts him on a plane to El Salvador, you agree you have no right whatsoever. If the president were to deport 10 million people from this country, under this particular act, none of them have any due process to challenge that. Like, on its face, it's just an absurd notion. Like, you can't possibly be making this argument in court, right? This is like comically stupid.
Injunction doesn't have to be against the president. I mean, the president said, I only want people who are members of TRO Nicaragua removed. And so if his lower level executive officials are removing people who are not, or who we don't know are members of TRO Nicaragua, the problem is not with the president's proclamation, it's with its implementation by lower level executive officials. And that's against whom the TRO runs. So there's nothing there about enjoining his war or national security powers. That is all about lower level folks who are not implementing the terms of the proclamation because they're not making sure these folks are members of the gang before they remove them.
Your Honor, I disagree with that for at least two reasons. First of all, that's simply not the basis of the TRO that was appealed. If you, again, on page 41 of the Saturday transcript, you'll see the basis that the district court gave for its second TRO. And that basis was explicitly not on having anything to do with individualized determinations that people were members of TDA. It had to do with second guessing the president's determinations that there had been an invasion. Second
guessing the determination of an executive? That's a very interesting way of saying due process. Should we go back and find that 41-page TRO, or find the TRO and read page 41? Like, this argument is just insane, right? Like, the cop said that you did this crime and you're going into jail, and you think you should, what, have a trial to second guess our brave police officers, to second guess the district attorney, to second guess the attorney general? What do you mean? Like, yeah, hello? What?
Or predatory incursion or threatened or attempted of the same, and that
Make sure I've got that. 46, is that what I heard?
41 of the Saturday hearing. Let me,
That's March 21st, right?
Sorry, that's
yes, Your Honor, let me get to that specific language.
Okay.
So what the district court said in explaining why it was issuing a TRO was, I think they, plaintiffs, have certainly presented a serious question that the president's proclamation is not legal under the AEA or a,
I just want
Sorry.
to make sure I'm on the same page as you. I'm looking at the afternoon transcript.
this would be the,
Oh, you know, I think I'm in the wrong transcript. That's my problem.
and I'm,
I think the
well,
transcript has line numbers, so if you could tell us the line number you're starting with. I think I have it, but just so we're all on the same page.
Yes, Your Honor, it's page 41, beginning at line 12.
Can somebody link the original? Can somebody link this so we could read along?
Sorry, that's my fault.
I'm sorry, let me pull that as well.
Totally my fault.
I think are they talking about the TRO that the court issued? Was it really that long, 41 pages or longer?
So what the district court said was, I think they, plaintiffs, have certainly presented a serious question that the president's proclamation is not legal under the AEA, or a different way of saying it is that the AEA does not provide a basis for the president's proclamation, given that the terms invasion, predatory incursion, really relate to hostile acts perpetrated by enemy nations and commensurate to war. Also, the terms nation and government do not apply to non-state actors like criminal gangs. And then he goes on without ever referencing, the opportunity to make challenges to individualized determinations under the AEA. So I think that's the order that you have before you. That's the order that we took an appeal of. And its basis is specifically the sort of second guessing of the adequacy of the president's determinations that statutory preconditions of the AEA have been satisfied. And the Supreme Court's decision in Ludecky and this...
It's second guessing. This is such an unbelievable argument, bro. It's like if the president comes out and says, like, everything about what he's doing is novel. Keep in mind the way that he's doing this is he's saying Venezuelans in this country are part of a foreign invasion because there's a gang called Tren de Aragua that also has members in the Venezuelan government. And even though there's not an official invasion or war between us and Venezuela, which the emergency that act requires you to have, they're saying that because some people have illegally immigrated to the United States that might be part of that gang, and because that gang is part of the Venezuelan government, that counts as an invasion into the United States, as like a state invading us. Therefore, the president can invoke this act to deport anybody who even looks like they might be part of Tren de Aragua with no kind of review or due process whatsoever.
Court's decision and Citizens Protective League specifically preclude such review. Here's how the Supreme Court described it in Ludecky. The very nature of the president's power to order the removal of all enemy aliens rejects the notions that courts may pass judgment upon the exercise of that discretion, end quote. Similarly, this court and Citizens Protective League recognize that, quote, unreviewable power in the president, ... is the essence of the act, end quote.
But it's like so crazy that, so you could just arbitrarily invoke this act for anything. Like, this is clearly talking about a time when you're at war with another state and there is an invasion, or people that are nationals of that country that are like invading you. Like, you can't just say that because that particular thing is unreviewable, that every single action the president does, as long as he says that, becomes unreviewable. That would almost be as stupid as giving the president absolute criminal immunity for anything he says is his official job.
The binding holdings of Ludecky and Citizens Protective League are controlling precedent here. In both, plaintiffs challenge the president's determination.
I don't want to, I could read these underlying cases. Ludecky or whatever is, there's no shot that they were talking about the president's ability to unrestrictedly, like, I bet that had to do with an actual war declared on an actual country and not just the president saying a gang being president of the United States counts as a war.
Determinations that one of the statutory preconditions there, whether there was a war that could justify invoking the act, was satisfied. In both cases, plaintiffs had very strong factual arguments. World War II had long since ended as a practical matter, and victory in Europe Day had been declared years earlier. As Justice Black
1948 case, Ludecky v. Watkins. Did this have to do this? Under the authority of the Alien Enemy Act of 1798, which empowers the president whenever there's a declared war between the U.S. and any foreign country to provide the removal of aliens. So this had to do probably, was this like the Japanese and everything for the our internment camps or whatever? Like this is during an actual, in the circumstances of relation between the United States and Germany, there exists a declared war, notwithstanding the cessation of actual hostilities, and the order is enforceable. The Alien Enemy Act construed as permitting resort to the courts only to challenge its validity and construction and to raise questions. Oh, wait. Hold on. Are we reading the syllabus? Because the Alien Enemy Act construed as permitting resort to the courts only to challenge its validity and construction and to raise questions of the existence of a declared war and of alien enemy status does not violate the Bill of Rights of the Federal Constitution. Construed as permitting resort to the courts only to challenge questions. Am I reading this correctly? Or does this point directly debunk, or am I reading this the opposite? Directly, like, contradict what he's saying? I shouldn't read the syllabus. Okay, let's go to, this is going to be on page 170 to 171. Whether and when it would be open to this court to find that a war, though merely formally kept alive, had in fact ended, is a question too fraught with gravity even to be adequately formulated when not compelled. Only a few months ago, the court rejected the contention that the state of war in relation to which the president had exercised the authority now challenged was terminated. Nothing that has happened since calls for a qualification of that view. This had to do, I think, I don't know why I feel like I've heard something about this case. Did we watch a Legal Eagle video or something? But I think it had to do with the fact that, like, is the war officially over, like, when the last gunshot is rang out, or can the president still exercise some wartime powers for a little bit after, or something like that? It is still true, as was said in the opinion in that case, which eyed the war power most jealously, we have armies abroad exercising our war power and have made no peace terms with our allies, not to mention our principal enemies. The situation today is strikingly similar to that of 1919, where this court observed, in view of facts of public knowledge, some of which have been referred to, and the treaty of peace has not yet been concluded, that the railways are still under national control by virtue of the war powers, and that other war activities have not been brought to a close, and that it cannot even be said that the manpower of the nation has been restored to a peace footing. We are unable to conclude that the act has ceased to be valid. Okay. The political branch of the government has not brought the war with Germany to an end. On the contrary, it has proclaimed that a state of war still exists. So one, we have a state of war with another country. The court would be assuming the functions of the political agencies of the government to yield to the suggestion that the unconditional surrender of Germany and the disintegration of the Nazi Reich have left Germany without a government capable of negotiating the treaty for peace. It is not for us to question a belief by the president that enemy aliens who are justifiably deemed fit subjects for internment. I wonder what that meant. Justifiably deemed fit subjects for internment during active hostilities do not lose their potency for mischief during the period of confusion and conflict, which is characteristic of a state of war, even when the guns are silent, but the peace of peace has not come. These are matters of political judgment for which judges have neither technical competence nor official responsibility. That brings us to the final question. Is the statute valid as we have construed it? The same consideration? Okay. To mean action support the validity of the statute, the war power is war power. If the war... Arguments find no defect in the act. The act is almost as old as the Constitution. Hold on. An argument to find no defect in the act because resort to the courts may be had only to challenge the construction and validity of the statute and to question the existence of the declared war, as has been done in this case. The act is almost as old as the Constitution, and it would savor a... Okay, so then it says here you literally could challenge, in this Supreme Court decision at least, but okay. I wonder, were there any processes or due process for people in internment camps before? I have no idea. If they could challenge like how they're being removed or what evidence had to be shown for it. Such great war powers may be abused, no doubt, but that is a bad reason for having judges supervise or exercise whatever the legal formulas within which such supervision would normally be confined in relation to distribution. Okay. The Congress accounts to replace it. Okay. All right. I just want to see the underlying thing.
Very strong factual arguments. World War II had long since ended as a practical matter, and victory in Europe Day had been declared years earlier. As Justice Black noted in his dissent, the very idea that World War II was still ongoing at the time of Ludecky was, quote, pure fiction. None of that mattered, however.
Wait.
At the time of Justice Black noted in his dissent, the very idea that World War II was still ongoing at the time of Ludecky was, quote, pure fiction. None of that mattered, however. President Truman's determination that World War II had not ended simply was not reviewable. Federal courts therefore lacked jurisdiction to hear challenge to the president's findings that the requirements of the AEA had been met.
This had to do with whether or not the war was ongoing after the Nazis had lost and the Third Reich disbanded. But there was a formal war declared against a formal enemy, and there are people who had already been justifiably deemed as coming under that act. I feel like this is a horrible stretch of what that case was about, but whatever. Well, but there's no good argument they're going to be able to make here, of course. It's just insane, but...
The same result must obtain here. As in Ludecky and Citizens Protective League, plaintiffs are bringing facial challenges to the president's determination that the conditions for invoking the AEA have been satisfied. And there is no basis for concluding that the president's determination that there is a war is wholly unreviewable, but determinations that there has been an invasion or a predatory incursion or threatened or attempted of the same is somehow reviewable.
So he also, but he,
Like, just to be clear, like, this is how this is cringe. So everybody agreed that we had formally declared war in World War II. Everybody agreed with that, okay? And then some citizens, I guess, came under this Alien Enemies Act, okay? And then I guess there was a Supreme Court challenge where there was somebody that tried to argue in the U.S., okay, hey, look, the Third Reich has collapsed. The war is over. And then the Supreme Court said, well, no, we can still say there's an ongoing war because a peace treaty hasn't actually been signed. So just because the Third Reich collapsed or whatever doesn't mean, just because the German Nazi Party or whatever collapsed, doesn't mean that we can say that the war is over, okay? We need an actual peace agreement. So wartime powers still apply. That argument has nothing to do with this novel, original determination of us being at war because a gang is in the United States. That's what's being challenged here. So when they're citing Ludecky, they're trying to say, oh, well, look, the court before said that the president is allowed to say that we're at war without a challenge to that. That was after a war was declared, and it was about determining when that war had formally ended. It wasn't about a novel declaration of war based on the fact that there's a gang in the United States. It's an insane, in my opinion. That's an insane citation. There is no congressional declaration of war. There's no formal declaration of war at all. The president has declared that we're at war with anybody. There's just an insane stretch to say that these things are comparable or that case even applies here. Because none of the litigants here, the plaintiffs here are not challenging the government's ability to declare war or to exercise wartime power. We're not even in a war. There is no declared war at all.
Or threatened.
Doesn't this imply there was an active war? Yeah, it was funny. I don't know if we watched this on stream or if this came up in the hearing I watched before stream. It was so boring. We're not going to watch it on stream. But somebody asked I think they might have asked Tulsi Gabbard. They were like, you guys did an assessment of all the current threats to the United States, right? And the person replied, yeah. And they were like, isn't it kind of weird that the current war supposedly that we're in with Venezuela didn't qualify for any of your assessments? Like, notice how you guys didn't talk about apparently we're actively at war with Venezuela and that didn't come up ever. What the fuck's up with that, right? Like, yeah. Do the lawyers know that and are acting in bad faith? On Trump's side, yes. The Trump lawyers are people that work with Trump. Well, it used to be Trump lawyers. Now he's actually smart enough to realize he has to rig the government. These are now White House lawyers. These arguments are obviously in bad faith. This is fucking garbage. It's garbage on garbage. It's on garbage. They're just trying to delay as much as possible and see how much bullshit they can sneak through. That's why they're doing so much illegal shit. Yeah.
But determinations that there has been an invasion or a predatory incursion or threatened or attempted of the same is somehow reviewable.
so he also, but he said, and again, I apologize, but I think this is line 10 to 11 of 41. It's outside of what Ludicky talked about.
Oh, thank
It's
God
outside-
they have. Yes. Okay. This is good because these are educated people, so they know what these court cases are about. It's not a fucking YouTube argument. Okay.
Of it. And we know what was outside of what Ludicky talked about, and that was the individual determinations as to their qualification, as to whether they qualify under the order. I mean, again, there's no question that that can be done. That's been argued in this case from the beginning. It's in the complaint. It's been argued about. That's the basis on which the government keeps saying you have to do this through habeas. There's just no question that he was basing it on multiple things, and one of which, and we now have the clarification from the district court judge this morning, is it's just about, all it has to rest on now in denying your motion to vacate is the right of them to have an opportunity, and there's no procedure as implemented by lower level officials that allows anybody an opportunity to challenge their status.
Your Honor, I
If
simply,
the TRO rests on that, it's to the extent, I understand that there's language on both things here, but to the extent it's resting on that, and that's what we've been told this morning, and it's here as well. It's at least part of it here, and it's what's been clarified now. To the extent it's resting on that,
Wait. Yes, but she is 1v2 on the judge's side. You will see later, which is why this is being tossed. She is overruled. What are you talking about?
there isn't an impermissible intrusion. It's fully consistent with our precedent in Clark and Ludicky, correct?
no, Your Honor, I simply don't agree with that. I think he told us on page 41 explicitly what his reasoning was. And I think you're reading a lot into that additional language and a whole nother holding that now exists in 37-page opinion form, but did not exist when the order was appealed and is not before you.
Well, can I ask, one of the things he said today, I just want to see if there's common ground between you and the plaintiffs and the district court.
Oh, wait, hold on. This was today? Oh, so this TRO did get stopped. They spoiled. Upon consideration of the emergency motions for stay, so a stay is when you stop. When you hear stay, legally think stay back or stay, stop. Upon consideration of the emergency motions for stay, the opposition thereto, the reply, and the Rule 28J letters, the amicus brief filed by South Carolina, Virginia, and other states, the motion to participate as amicus curiae, filed Representative Brandon Gill, and the lodged amicus brief, and the motion it is ordered that the motions to participate as amicus curiae be granted. The clerk is directed to file the lodged amicus brief. It is further ordered that the emergency motions for stay be denied. Separate concurring statements of Judge Henderson and Judge Millett and a dissenting statement of Judge Walker are attached. So then, will this end up going to the Supreme Court, or? Wait, it's further ordered that the emergency motions for stay be denied. Never mind. The motion for, I'm sorry, I was reading the motion for the TRO or whatever. Okay, wait, so this says it. Wait, who said the opposite of this? Yeah, sorry, I read this backwards. Okay, never mind. I don't, this person in chat is retarded. Okay. Stop spoiling also. Fuck you.
He said, before they may be deported, they are entitled to individualized hearings to determine whether the act applies to them at all. I think you agree with that. Do you agree with that?
Say that again.
Entitled to individualized hearings between you and the plaintiffs and the district court. He said, before they may be deported, they are entitled to individualized hearings to determine whether the act applies to them at all. I think you agree with that. Do you agree with that?
I agree with part of that, Your Honor, in that he cites to a number of different cases that allow for such review in habeas proceedings. And so to the extent that someone were to bring a habeas challenge, review of some sort along those lines is, you know.
So let me just, I'll use your words and then make sure that we're on the same page. To the extent that it's brought in an individualized habeas challenge.
When people say like habeas challenge, they're talking about habeas corpus. Do they just mean like the ability for you to have like formal charges brought against you? Is that what that's, or some kind of like formal due process to challenge, like an arrest or to challenge some state action depriving you of your freedom? Basically, is that what that means? Basically,
They are
to be
entitled to
brought in front of a court?
individualized
Yeah,
hearings
okay.
to determine whether the act applies to them at all, correct?
Your Honor, there's certainly precedent to support that. It's not precedent of the Supreme Court, so the exact contours of what a habeas court might hold are unclear, but I will certainly acknowledge there are cases that are habeas cases that exercise review, certainly of that sort. Ludecky itself exercised review over a due process challenge, and that was reviewable. It just simply had no merit whatsoever. This court itself and Citizens Protective League exercised similar review over constitutionality, but again, just thought there was no merit there.
Well, let's say that, 'cause I understand you not to be affirmatively endorsing, but not to be affirmatively contesting the statement that if they bring it in an individualized habeas petition, they're entitled to individualized hearings to determine whether the act applies to them at all. In other words, they bring a habeas petition, they can say to a federal district judge, I am not Trende Aragua. And a federal district judge would review that, at least to some degree. It sounds like you're not affirmatively endorsing that, but you're not arguing against it. If that is true, that they can do that, how would that work? My understanding is that in some ways it's already working. There are some individualized habeas hearings being held in Texas where the detainees are being held. So can you just help me understand? This is, I think, is a friendly question. So if they can bring a habeas petition to say, I'm not a member of TDA, so you shouldn't remove me under the president's proclamation, how would they bring that habeas claim? What would that look like?
Certainly, Your Honor. So that they can bring an individualized habeas claim, and at least some arguments are certainly available in habeas. Ludecky itself reviewed a due process argument in the habeas context, so certainly at least that is available. The precise contours of that would be resolved by
He's going to say there's no answer. Sorry, Jesus. Every time I get to the precise contours, who knows what it would be?
Habeas courts, but to your question of how would this work
Who the
is
fuck knows?
how it is working in Texas right now. Courts are deciding that. How it absolutely cannot work is how the district court has.
I know that's what you think. I'm not saying I disagree with you about that. So let's say they're being held in a detention center in Texas, and they want to file a habeas petition to stop their removal under the proclamation. Would they have access to a court to do that?
They would certainly have access to a court to do so, and many have done so.
And that's important too, what you just said. Many have done so. These habeas hearings are ongoing now, individualized habeas hearings in Texas.
That's correct, Your Honor.
Okay.
Were the people that were on the airplanes last weekend given an opportunity to file habeas?
Well, Your Honor, that we are here on a case in which the 5 individual plaintiffs were able to get in court and were able to get a TRO, and therefore were not on planes. And so they.
But one or so was on planes and got removed.
What's that? Of the 5 named plaintiffs? That's not my understanding, Your Honor. All 5, the government has represented that those 5 were not placed on planes, that the 5 that had the benefit, the individual plaintiffs that had the benefit of the first TRO who were able to get in court in time.
In this process that I'm describing, the 5 named plaintiffs here who did file in this court before they were removed from the country could have, you tell me if this is wrong, could have just as easily filed in a Texas district court a habeas petition in the district where they're being held.
Absolutely, Your Honor. And notably, in the complaint that was filed in this case, they did raise habeas action, a habeas claim. It was count 9 of it. And
They didn't just raise it. It was the title of their complaint. Their title of their complaint, I think I have it somewhere here, was class action complaint and petition for writ of habeas corpus. And they later said, plaintiffs respectfully pray this court to grant a writ of habeas corpus to plaintiffs that enjoins defendants from removing them under the Alien Enemy Act. And those are ongoing in Texas, you're saying. Some of those are ongoing in Texas.
Absolutely, Your
Let me
Honor.
ask this, is the government detaining anyone solely on the basis of the Alien Enemy Act?
Your Honor, I would have to check that specifically. Almost everyone is being detained additionally under Title VIII. I'm not sure if there are any specific AEA.
So this is a question I had yesterday. Are any of the people on the named complaint people that were deported without due process? I was curious about that. And I think none of these people have been deported yet. So what this judge is asking is like, well, these guys are filing court cases, right? So that means anybody can, right? Is essentially what he's saying. I don't know why these are the 5 that have filed the court case, other than the fact that the other people already got deported. So maybe that's, they didn't have a chance to file the court case. But even though there's only 5 named people on this complaint, though, I think it would apply to everybody that this is coming under, everybody that this impacts, all the people that would be deported under this act. Yeah.
Only detentions, certainly.
He's using such cucked language. I think it's a friendly question. What the fuck? Well, because this judge, I think, agrees with the government's arguments. Like when you listen to oral arguments, usually you can tell which way they're leaning. And this judge, my guess is he's probably leaning that the government is justified in doing this, which is why he's asking him questions to explain, like, other people have already had due process, right? Like they literally have, right? Yeah.
Or if there are any specific AEA, only detentions, certainly. But the challenge has been brought to that.
I'd be curious to know if you can find out and if it wouldn't reveal, something too sensitive to reveal. If there's anyone being detained solely on the basis of the Alien Enemy Act.
Your Honor, we're certainly happy to track that down and provide that information to the court.
Thanks.
And
It seems like the relevant thing is where people being removed solely, not detained, but removed solely based on the proclamation. It seemed like, and again, you can clarify for me, I'm just looking at a cold record here, that the proclamation was signed and people were getting put on planes immediately without even notice as to the basis.
That might be true, but my guess is the government's going to want to restrict this complaint as narrowly as possible to just the named people on the complaint and not talk about those. But
let alone an opportunity to file suit. And so for those removals, I think there was one airplane that you said that was people were removed on other grounds, but there were 2 where the government hasn't argued that. Am I recalling the record correctly?
Your Honor, I believe so. I mean,
2 planes worth of people removed under the AEA, not under withholding of removal process, or removal, the ordinary INA removal.
the Title VIII process. Yes, Your Honor. But
how long is the video? 2 hours. Come back later.
I think the fact is that 5 individual plaintiffs were able to march into court, file habeas, actually get relief, admittedly on non-habeas grounds. And the fact that opportunity.
Without the government, I mean, that was a super fast order that was done, as you know. I mean, the government was called and notified, and then a hearing that afternoon. But that's one of the reasons there's all these separate disputes in district court about compliance, because planes were already loading and taken off. And those folks did not have notice or an opportunity to challenge their status at all. And that's why there's had to be a class certification to slow things down until we have an opportunity for due process.
Your Honor, I think this court's decision in IM versus CBP is instructive on this.
Am I wrong about anything I just said factually?
Planning to watch the controversy video later? Probably not. It's way too long.
Your Honor, I think it's incorrect that they couldn't have gone into court as the 5 individual plaintiffs.
No, but
also
the point here was that
Jesus.
there were plane loads of people. I mean, it's a class action. There were plane loads of people. There were no procedures in place to notify people.
That they were going to be
Nazis got
subject to
better
this.
treatment under the Alien Enemy Act than has happened here, where the proclamation required the promulgation of regulations, and they had hearing boards before people were removed. And yet here, there's nothing in there about hearing boards. There's no regulations, and nothing was adopted by the agency officials that were administering this. People weren't given notice. They weren't told where they were going. And they were given, those people on those planes on that Saturday had no opportunity to file habeas or any type of action to challenge the removal under the AEA. And like you've agreed that 2 of those airplanes, people were removed under the AEA.
This is part of why the judiciary is so upset about how these people were deported, is because this order apparently was signed like at night or in the evening or whatever, and then they started deporting people basically immediately. There was probably no realistic way by which any of the deported people could have actually challenged any of these deportations, because they were like, they barely even realized it, and then they were getting deported. It was like, oh shit, wait, what the fuck? Like they had no clue, and then they're on a plane and they're being shipped out of the US.
What's factually wrong about what I said?
Well, Your Honor, we certainly dispute the Nazi analogy, but more importantly, the fact is that...
Wait, fuck, did I miss a Nazi analogy? To be fair, I'm not sure people needed to be informed they'd be subject to this before they were possibly deported. Usually, legal deportations aren't announced beforehand, I guess. What? Yeah, of course you have immigration courts and stuff where deported people have like due process and all that.
Well, Your Honor, we certainly dispute the Nazi...
Any type of action to challenge the removal under the AEA. And like you've agreed that 2 of those airplanes, people were removed under the AEA. What's factually wrong about what I said?
Well, Your Honor, we certainly dispute the Nazi analogy, but more importantly, the fact is that individual plaintiffs were able to file habeas in time in order to secure relief.
Wait,
And
what
with this court,
individual plaintiffs were?
the 5 individual plaintiffs that...
He's playing word games. He's being a fucking retard. She's clearly not talking about it. She said multiple times, this is why it's a class action. It's because the original people that were impacted by this didn't... I don't even know why I'm saying that. I don't know why the judge is going to have to repeat herself. She's not talking about the 5 listed on the complaint. She's talking about the people that were already fucking flown out because of an order signed like in the middle of fucking night to start deporting people.
Secure relief.
Wait,
And
what
with this court,
individual plaintiffs were?
the 5 individual plaintiffs that
That's
got...
not my question. My question
Yes.
is there were a lot more people. They wanted to bring a class action. They had to have some named plaintiffs.
Yes.
So 5 people filing habeas doesn't help everybody else on 2 airplane loads. Correct? And my question to
Correct?
you is...
No! Make him answer that. Correct? Right? Do we know why we're here? Hello?
And you said those 5 didn't get put on the airplanes. So as to the 2 airplanes that I think you just agreed involved removals solely on AEA grounds, on Saturday, the very short time of the proclamation's publication, had no opportunity to file for habeas or even notice as to the grounds on which they were being removed. Am I wrong about that?
I think so, Your Honor. The fact that 5 individual plaintiffs did file...
It's such bullshit. I know you can't be held in contempt for fucking being a debate pedophile, but like he's just... Do you understand the argument going back and forth? So let's assume that like 5 people died because of some bad medication, and like 10 other people brought forth a class action lawsuit representing everybody who took this medication, you know, for relief from the pharmaceutical company or whatever that sold the drug. And they're like, well, part of this issue is that like you can die, you know, taking this medication. And then the defense is arguing, well, hold on. None of the people on the complaint died. What are you talking about? It's like, well, no, of course not. But the people that aren't on, that's why this is a class action. It involves like some people who are dead as well, right? Maybe their family members get paid or whatever. Right. So you understand that like part of this has to do with like the people that died or whatever, you know, like their families deserve relief or whatever, right? And it's like, excuse me. And then the defense is, well, hold on, but none of the dead people are on the complaint, ma'am. So I don't know what the fuck you're talking about. And the judge is like, bro, this is a class action. What are you talking about? Those people are obviously under the umbrella of what we're talking about. That's what they're going back and forth on. And the defense here on the government, when I say government, and we're talking in court here, the government is the DOJ, the Department of Justice, representing the federal government right now. So the people that did the deporting. The federal government keeps going back and forth. They're saying, well, the 5 people that are on this complaint, they didn't get deported, so they've obviously got due process. And then the judge is representing the plaintiffs, who are part of, just happen to be 5 people on the complaint, are suing on behalf of everybody that could be deported here, saying that, well, of course, those other people aren't on the complaint. They were deported. They didn't even have a chance to file a complaint. They didn't have a chance to file a complaint, right? And then the guy says, what are you talking about? These people filed a complaint. And then the judge goes, yeah, these people did because the other people couldn't. That's why it's a class action. And he's like, but didn't these people file a complaint? Like, it's a fucking retarded argument. This is retarded. This is retarded.
Am I wrong about that?
I think so, Your Honor. The fact that 5 individual plaintiffs did file habeas and did get relief indicates that they could.
I don't think you're answering my question.
No, he's
My
not.
question is not as to the 5 plaintiffs. How much time, I want you to think of 5 other people on the first airplane.
Yeah.
How
Like,
much,
does she realize? I wonder sometimes if like judges, when they deal with like these Trump cases, if they have the same thoughts that I do when I'm doing a debate, where it's like, why am I asking this retarded fucking question? Like, she's about to ask a retarded question. I'm not talking about these 5. How much time did the people who were part of the first deportations have to file for a writ of habeas corpus? How long did, like, that's what we're all talking about here.
time when were they given notice that they were being removed under the AEA on the grounds that they were members of Tren de Aragua?
Is he going to find a way to say, I don't know how much time they had, Your Honor, but these 5 on the complaint did. They found time to do it. So I don't know why they did it. Like, I don't know, man.
And how much time were they given between that notice and being put on the airplane that Saturday, right after the proclamation was signed, to file a suit?
Your Honor, those facts are not in the record, and I don't know all of them offhand, but I think.
Okay, so go ahead, you think?
But I think the fact that 5 individuals were able to do so.
No.
Oh, he did it! What the fuck? Wait, this is a meme. These are meme arguments. This is a meme. These are meme arguments. This is like getting lost in hell in a shitty Reddit argument with some guy that keeps responding to you with the same debunked argument like 2 comments ago, and then he goes back to 1 comment ago, and then in the next one he goes back 2 comments, and he just, holy shit.
Others could have.
They filed suit before the proclamation was even published. I've asked you after the proclamation was published. And I assume these habeas actions that you're talking about, and correct me if I'm wrong, that are now being filed in Texas, have been filed since there's been a stay.
Well, Your Honor, I'm talking about
that right?
the 5 individual plaintiffs in this case.
That's not what we're talking about. Oh. Can you ever, where's that lawyer dude? Can you ever be like held in contempt for making dog shit circular arguments over and over again? There must be some way to do it, right? Like if you were in court and you just kept like repeating the same shit that was debunked, you have to be like declared insane and then removed or something, right? There's no way you could actually do this, no?
That's not my question.
I understand.
The question here is,
Why did she have to repeat herself again?
thinks there was a meaningful opportunity, notice and opportunity to file for habeas for the people on those 2 airplanes. They're not these 5 named plaintiffs.
Yes, it's not these 5. They're different people, right?
Because they filed before the proclamation was even published. If there was no opportunity for those folks to file habeas, then that's the issue for the TRO, to freeze things in place so that compliance with due process can occur.
Right?
Well, Your Honor, as to due process
You
claim.
haven't disagreed with any of my facts about there wasn't time for the people on those
This
2
is like my debates where I'll say like, okay, what do you care about? I care about the deficit. Okay. Trump raised the deficit, right? Yes. It was during a time of economic prosperity, right? Yes. He didn't do anything to control spending, right? Yes. There's no reason to think he's going to do anything about spending, right? Yes. In fact, all of his stated positions, like renewing the tax cuts, expanding those, that would all increase the deficit, right? Yes. So why the fuck do you like Trump again? Because he's good for the deficit. What? This is like every conversation I've had with somebody who claims that this deficit thing is really important to them. It's like, but you agreed with me with all the facts, right? You agreed on everything I said. Yes. Then why is Trump going to be good for the deficit? You need to understand something, Stephen. There's a little thing called wokeness, and it was going to destroy this country.
airplanes. You haven't
Your Honor,
one at a time. Were they given notice before being put on the airplane that they
These 5 filed, didn't they?
were being removed?
Bring up the 5 again. Please bring up the 5 again somehow. Bring up the 5 again somehow.
Because they were members of Tren de Aragua pursuant to the president's proclamation.
Bring up the 5
under
again.
AEA.
Bring up the 5
Your
again
Honor, I
somehow.
don't think that is in the record.
We
But
don't
these
have-
5.
We can't speak for the government with knowledge about that.
No.
Your Honor, my understanding on public news reports is that they had some sort of notice. I don't know the specific contours of that. But again,
You are allowed to cite that? You'd think as the government, you'd want that maybe as part of the record. No? Like you're challenging a TRO. Wouldn't part of the challenge of the TRO that has to do specifically with due process be you citing due process that was afforded to these people as a basis to stay or reject the TRO? Like, wouldn't that be an important thing to do? Like,
Again,
Okay.
our position
So we
is the
don't know
fact.
that- So there's no record that they were given.
And if there's no record, then fuck you. This is a court. This isn't an e-debate. This isn't a Twitter thread. If you don't have something to submit to the record, then there's nothing for you to reference. Why are you bringing up fucking media reports, dog? What does that have to do with fucking any of this shit? Media reports? Submit something for the court to actually look through.
Notice. And then how much time was there between the president's signing of the proclamation and the first, or those two planes taking off?
Your Honor, that's not in the record. I don't know that
But
specific.
you had the times of those planes
Oh, wait,
down pretty clearly, and we know what time the president's proclamation was published.
Your Honor, the record has what times that they had departed before the 7:25
But
p.m.
that must be findable, what time the planes took off.
Your Honor, it's that is currently the
Oh
government is
my
currently
God.
engaged in
Oh my
evaluating
God.
what if any of that can be disclosed.
What
And that's,
time?
You can't disclose when an order was signed or when the planes took off. You don't think can't you just look up publicly like the air traffic control tower? Like, give me a break. Like, this is a joke. And this lady, the judge is a joke. All these judges are jokes. I'm sorry, I don't know anything about the actual process here, but like, they're spitting in your face. We're talking about TROs. These aren't even ordinary court cases. These are temporary restraining orders that are already extraordinary. The fact that we're appealing TROs, in my uneducated, unlegal educated opinion, is already ridiculous. And now to go and fight against a TRO, you're not even fighting against a preliminary injunction. You're not even fighting, which is what the TRO is supposed to do. You're not even fighting against an injunction. You're fighting against a TRO. You don't even bring evidence for your fucking case. Like, TROs traditionally are only, they're ex parte anyway. You're not even supposed to have any input. You're not even supposed to have a say on the TRO. It's literally just from one side. And the fact that you want to come and fight it, but then you don't even bring any evidence to support your argument? Like, what are we even talking about here? What is happening? Your Honor, it's classified. Can you please get rid of this? Like, this is so cringe.
You can tell what time the planes landed, but you can't tell what time they took off.
we have told what time that what their status as of when the 7:25 p.m. minute order issued. And I'm not authorized to to discuss any more operational details
Okay,
of
is
that.
the government aware of how long it takes to fly from wherever this airport is in Texas to El Salvador,
Maybe they flew in circles, Your Honor.
or generally?
Your Honor, I don't know that off the top of my head.
And that can be found out pretty easily.
I'm-
Time. I mean, it just feels like there was no time. And the habeas cases you're talking about now were only able to be filed because the district court froze things.
Well, Your Honor,
Right?
this case itself was originally filed as a
Are there
habeas action.
other habeas cases that you mentioned filed in Texas? When were they filed?
Your Honor, at least I believe at least one of them was filed, but before the plaintiffs indicated that they thought the plane had taken off. That I can track down, but that's my recollection.
The other ones have all been because there's a stay in place.
What's that? You know, I don't know the precise status of every single one of those individual habeas actions. That's a
Well,
very
I don't know how they
fast.
could have been filed before the president's proclamation was made public. And before someone was told that they were being subject to it, right?
Your Honor, again, I just
Otherwise,
disagree.
it wouldn't be a right claim.
Your Honor, we're here because 5 individual plaintiffs filed a complaint that clearly include.
Bro, it's actually so ridiculous. This is so fucking retarded. What is this is such a stupid, this is so dumb.
Included habeas claims, as Judge Walker indicated, and here we are hearing that very claim. And here's what this court said. Excuse me, in IM versus CPB, IM contends that a removed alien may file a habeas petition if extreme circumstances prevented him from filing while he was in custody. We disagree. Lower courts are created by Congress and have only the jurisdiction Congress grants, no more, no less.
And and then their contention is that since these people are already out of the country, the courts no longer have the ability. Like, it's so convenient. If I just fly an American to Mexico, I can do whatever the fuck I want with him. And a court, like, I don't know why I keep saying it's just so on its face. It's such an obviously fucking stupid argument.
And, you know, Your Honor indicated that you thought that this was a matter of due process, but I think that's very useful here because the Supreme Court and this court have confronted due process claims challenging the invocation of the AEA. And, here's what Supreme Court said.
I don't know why you retards in chat. I know it's a popular lefty talking point or whatever. The Gitmo, 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 Gitmo. Even people in Gitmo were able to challenge their detainment in Gitmo. Also, we're not talking about removing people from the USA generally for Guantanamo Bay. No, wasn't that for people captured in other areas like overseas? I don't know why you guys keep trying to compare Guantanamo Bay to this, because even those people were for more rights, and it's not the same type of person that we're even talking about, and it's not the same powers that are being invoked. I don't know why you keep bringing up Gitmo, Gitmo. Like, it's so retarded.
It said, the act is almost as old as the Constitution, and it would savor of doctrinaire audacity now to find the statute offensive to some emanation of the Bill of Rights, which obviously includes
I'm saying the whole
That has
statute.
nothing to do with, no one is challenging the statute here, right? We know where that case is coming from. No one is challenging the statute or the construction of the statute, any of that. This is such a...
the statute offensive to some emanation of the Bill of Rights, which obviously
I don't
includes
even know... Oh, it's so dumb.
I'm saying the whole statute's under Constitution. No one's saying
No one's
the
saying
Alien
that.
Enemies Act.
Yeah,
Well,
no one's challenging this.
maybe they'll tell me they're saying that, but the entire Alien Enemies Act is unconstitutional. That has been decided. The question is whether a particular proclamation and its implementation is constitutional. This happens all the time. The statutes are constitutional, but how they're implemented
Yes, it's a different level removed. That's why it's such a... It's...
in a particular case is not. That's all we're talking about. And in Ludicky and in Clark was a case like this one. It wasn't a habeas, sorry. I used a shorter name for the case in this court, Clark. It was 159 people and an organization who represented their interests who filed suit. And we recognize there that you could have a challenge to whether you qualify under the proclamation, right?
Your Honor, I don't
And
think
that's the issue here, is whether there's a process.
I agree that that's how the district court saw it, but there were due process arguments raised in those cases as well.
But these 5 on the complaint, they've already done due process, right?
And this court said that if there was the slightest question in the minds of the authors of the Constitution or contemporaries concerning the constitutionality of the Alien Enemies Act, it would have appeared. None did.
Yeah, that's the constitutionality of the act. You just finished the sentence for me. My question is, and I think what just constitutionality.
The slightest question in the minds of the authors of the Constitution or contemporaries concerning the constitutionality of the Alien Enemies Act, it would have appeared. None did.
Yeah, that's the constitutionality of the act. You just
But
finished
we're
the
not
sentence
talking
for
about
me.
that.
My question is, and I think what district court
What's
here.
the whole point of like being a lawyer and having like the philosophy brain and like doing it like the LSAT and your law school? Like, what if you can't even like understand? Like, this guy is arguing like a Twitter retard, right? Who can't understand like basic logic. It's just like so fucking cringe. Like a police officer walks up to you and shoots you in the fucking head. And it's like, bro, cops can't do that. It's like, excuse me, ma'am. Executions are legal in this state. Yeah, but you have to be like, you go to court and you get convicted of everything first. You understand that, right? It's like, okay, yeah, people have gone to court and been convicted. Okay, but this person wasn't. The cop shot and killed him. Yeah, I'm aware of that. You're allowed to execute people. Hello? Yeah, but like after due process, yeah, people, like, it's the most circular, retarded argument. Is he clearly acting in bad faith? Yeah, you're right. It probably is clearly, it's just a stall bullshit. All of this is bullshit. Like all the Sidney Powell and Giuliani cases were all bullshit. The Kraken, yeah. It's just, this is, whatever.
Hasn't called into question the
The judge should get more ornery.
constitutionality of the Alien Enemies Act. It's been upheld, as you said, as a part of the war power. But, so that's not the question here. The question is
Like,
whether
how many times
the
does she have to repeat that?
implementation of this proclamation without any process to determine whether people qualify under it. I mean, if the government says we don't have to give process for that, then y'all could have picked me up on Saturday and thrown me on a plane,
Yep.
thinking I'm a member of Nicaragua and giving me no chance to protest it and say somehow it's a violation
Yes.
of
I was
presidential
saying earlier she should use a child as an example, but yeah, that's right. Yes, correct.
war powers for me to say, excuse me, no, I'm not. I'd like a hearing.
Yes.
He wouldn't say that.
He's going to say, well, that's why the 5 people on this complaint have filed for habeas corpus. See, so everything's good. He's going to say it. He's going to loop. We're going to loop. He's going to say it. He's going to say it.
Your Honor, obviously nothing of the sort is presented by the record here. I think what
No, we don't have any record
of you allowing them to, we don't have a record of you allowing them to any due process at all.
Whether these individuals are members of Nicaragua or victims.
Or that at all either, which would be part of the due process, is proving, or at least providing some evidence that they're actually members of Nicaragua. Yeah.
Of Nicaragua.
Your Honor, as you've characterized it, what that sounds like to me is an argument that the AEA
is unconstitutional
because it does.
Oh my God! Because we're not even in a declared war. Okay, sorry. I'm just gonna let this play. This is stupid. There's no point in even pausing. This is just fucking retarded.
Doesn't provide for
It's
pre-deprivation.
not an argument about the statute. I'm going to tell you. I'm going to say this.
One more
I don't
time?
know how to say it any more clearly.
Thank you. Yeah, tell him. Do the debate pedophile shit. I'm not going to repeat, or I'm going to say this exact same thing. Every time you bring this point up, I'm going to say the exact same thing over and over again. I'm going to ask you the same question, no matter what retarded shit you're about to say.
My questions are about the implementation of a particular proclamation under the statute. That is not an argument. And quite frankly, the statute provides that there will be regulations issued. And regulations to determine someone's status have happened every other time the statute's been used.
Oof.
So this isn't about the statute.
I haven't even read that. If that's the case, that's another huge blow to the government's argument, is that although my guess is before, it's probably pretty easy. I think someone in Kicker YouTube chat said this, that it was probably trivially easy before, because if you're trying to hold like a German citizen, determining whether or not somebody's a German national is very easy. You literally check their visa, check their paperwork, they have a passport, right? But so it sounds like the statute itself literally does provide for a process by which you verify the person qualifies for what the statute is claiming, you're a part of.
Statute being unconstitutional. It's whether implementation of it under this proclamation is unconstitutional. And not even, is it unconstitutional? Is there a likelihood of showing that there's a constitutional problem here because of the lack of due process? We're not even deciding the merits. So please do not attribute to me that I'm saying the statute's unconstitutional. You and I agree that that has been answered. But implementation of a proclamation is a completely different question. Can we agree on that?
Your Honor,
You won't agree, I mean, maybe that it's constitutional problem, but you agree that it's a separate question whether the implementation of something under a lawful statute is constitutional.
Your Honor, certainly at that level of abstraction, I agree with you. I see that.
Drilled down exactly what this case is. That's not abstract.
Well, Your Honor, where I disagree is that, as Your Honor identified, the AEA requires the issuance of regulations. It does not require the provision of pre-deprivation process. And so I think that would be an argument that under the Due Process Clause, the failure to provide of the AEA itself to mandate pre-deprivation hearings is unconstitutional. And I think that is the sort of challenge that was considered and rejected.
When were other usages of the AEA done and people were summarily removed without advanced process? Can you show me an example in history when the AEA was used that way?
Yes, Your Honor. So in Ludecky, for example, there was a requirement in the implementing regulations that that an alien had to be dangerous before that they would be removed, and there was part of the challenge was that person was not dangerous.
Okay, but this isn't whether or not they qualified necessarily under like the nationality of a person that you're like at war with, right?
And wanted to challenge the Attorney General's determination that he was. And what the Supreme Court said is that President Truman, provided for the removal of such aliens as were deemed by the Attorney General to be dangerous, but such a finding at the President's behalf was likewise not to be subjected to the scrutiny of.
Different question. All right, footnote 5.
Like you have to understand, I'm sorry, I'll say this one more time and then we're done. You have to understand, if the government were to succeed on the merits of this argument, what the government is essentially arguing is that anybody in this country can instantaneously be removed as an enemy alien without any evidence being presented, without you ever getting to be in front of a court, without they can just say, hey, we think you're an illegal, or not an illegal, I'm sorry, we think that you're part of this gang, hop on the plane, you're out of here. And that's it. You get no questions asked. If the government's argument was correct, that's what they would be arguing for. It's just an insane argument, but.
The order recited that the petitioner was deemed dangerous on the basis of evidence adduced at hearings before the Alien Enemy Hearing Board.
Oof.
That's what I'm talking about. They had a process there for the decision. Question whether a court can review whether a secretary properly deemed someone dangerous. That's what they said. That's committed to the discretion of the secretary, whether someone's deemed dangerous. But there was hearings and there was process. I asked you when they haven't had process.
Your Honor, I guess then that points to me that this conversation has been very much about due process, but even as the 37-page, opinion that issued this morning, it seems to sound in due process, but doesn't hold, make a holding based in due process. And so,
oh my God, he was citing this case to win his argument. She points out that this argument doesn't, like, not only does this not support your argument, it actually goes contrary to your argument because the due process exists here. And then he's saying, whoa, shit, that's true. This is against me. Well, I'm going to say that the, I believe it's called a dicta, right? That the part of the ruling about this that had to do with the due process, that's actually not the holding the case. That's not the important part. That was like extra shit that he talked. Now he's arguing against, it sounds like, if I'm understanding, she's arguing against the case that he just brought up, in that the holding of the case isn't even relevant to what they were talking about at all. And the fact that the case contradicts him, that part of it isn't even important. It's just memes.
that alone.
Well, it says it's limits. That's how, it's not holding because it's a TRO. It says it's
Oh, that's true. Yeah. And these are temporary restraining orders. These aren't like Supreme Court decisions or like crazy, like, where there's huge holding that can be cited as precedents or whatever. But
limiting its likelihood of success analysis to that question. And then to get, if you want to respond to that, because I wanted to get to this question of whether it can only go through a habeas, but I wanted to let you.
Your Honor, we think that the rationale has been swapped out at the last minute, less than 4 hours before oral argument. We think that's procedurally improper and potentially jurisdictionally problematic, where the ordinary rules of jurisdiction do not permit district courts to present this court with a moving target on appellate review. And I think that's exactly what you have here.
Another procedural problem here is that you never sought a stay from the district court.
That's correct, Your Honor. This is obviously.
Oh, wait, what? Okay, so it sounds like the guy is saying that you're not allowed to, I don't know what would you say, amend the complaint. You're not allowed to change what you're arguing between the lower court, the DC court, and then this appeals court, your circuit court. But then her counter is, okay, maybe that might be true. However, you didn't even, it sounds like you didn't even apply for a stay of the TRO to cancel the TRO at the lower court level. You literally instantly came to the Court of Appeals for this. I don't know how you determine if somebody's allowed to do it or not, but.
You've had plenty of time. You've had a week, more than a week. You've never sought a stay from the district court first, which our precedent require.
No, Your Honor, it certainly that is a general thing. This case is absolutely extraordinary that we moved within mere hours for this court. It obviously was not possible to exhaust before the district court in that time.
Before the court, I don't mean you personally, the government was before the court Saturday afternoon in person when the TRO issued, right? There was a government attorney, it was you or someone else, but there was a government attorney before the court Saturday afternoon when the operative TRO now was issued, correct?
That's correct, Your Honor, although.
The attorney have said when the TRO was entered, we request a stay so we can seek relief from the Court of Appeals. Did they have time to do that at that hearing?
I suppose so, Your Honor, although.
Seek a stay.
Your Honor, a couple things let me say about that. First of all, that TRO, it was scheduled as a hearing for class certification that the government was surprised to discover, and I was personally just surprised to discover that the TRO merits would be discussed. The hearing was only set for class certification, and on that question of class certification, the government was not permitted to file even a single sentence of written briefing in opposition before we were hauled into court on a Saturday at 5 p.m. and a nationwide class action or class was certified. And
okay, so it sounds like it was an argument for certification for the case to be considered a class action lawsuit. That's an extra thing you have to, I guess, apply for, and that's what it was about. However, for him to complain that we were dragged into court on a Saturday and blah, blah, you signed this order. This order was signed for the deportation shit, like on a fucking Friday evening. Like, yeah, no shit. You guys try to play the system hard. Listen to like there's like a, I don't want to say contempt in his voice, but there's like a, I can't believe you guys fucking heard this on a goddamn Saturday. Like, we filed this shit on Friday just so we wouldn't have to do this shit for like 3 days. Like, that's, if I'm interpreting all that correctly, that's a pretty unbelievably mischievous line of intent, I would say. But
and then in that posture, we were then surprised to discover that, notwithstanding the fact that the notice was for a hearing on class certification, that in fact a second TRO would be, the merits of which would be considered, that was presented there. We certainly believe that it wasn't
Still don't understand how that means you didn't have time that afternoon, or Sunday, or Monday, or Tuesday, or Wednesday, or Thursday, or Friday, or Saturday, or Sunday, or this morning. Ask first day from the district court. You've had time, correct?
Your Honor,
We had time, yes or no?
we've had
There we
time.
go.
It's clear
Yes.
that we went to this court. Your Honor, certainly too, this is not, I believe, an issue, the FRAP 8 compliance that plaintiffs have raised. So it's by itself may have been forfeited because that is not an argument that I believe that plaintiffs have raised. But before that, we had already sought a first stay.
You admitted it right in your filings with us. You teed it up. They didn't have to raise it. You teed it up in your filings that we didn't do this. Do you know how often the government has asked this court to dismiss stay applications because someone didn't first ask it before?
Your Honor, I acknowledge that is a common course in cases.
The process and procedure. So remember, one of the things I say about like a cease and desist is important because you're putting up a defendant potentially on notice, and you're showing the court that you're making a good faith effort to like get shit done. Courts do appreciate like process and procedure, and if you go contrary to them, a judge might rule against you just because you're wasting the court's time, or you're showing disdain for the accepted, rules and procedures of the court. Like, they only have so much time, and they have to read through this shit, and they have to be prepared for everything. And if you're not respecting their time, then they might toss shit or say, fuck it, you didn't even try this out here first. Like, fuck you,
There's nothing remotely ordinary about this case, and certainly not.
But what is very ordinary is that you had plenty of time to ask.
file beforehand, yeah.
And
I
you
don't-
not only didn't, but you did have, you had the time to type into your briefs here. We didn't ask the district court for a stay.
Your Honor, because we thought, frankly, candidly, we hope this court might act more quickly, and
Okay, then don't make the other argument, you fucking loser. So it wasn't about you not having time. Notice the shifting goalposts. We didn't even have time to file in the fucking DC court. We didn't have time in the district court. And now it's, well, we were hoping you guys would kind of like do this shit a little bit quicker, right? So it's not that you didn't have time. It's that you wanted a faster answer by fast tracking this to the Court of Appeals. Does it go, if you start in the Court of Appeals here for the, asking for a stay for this, does it get to the Supreme Court faster as well? Like, can you, I don't know if you can do like a writ of certiorari from a district court, or if it has to go through the circuit first. Like, so this is what you're actually saying. You just wanted this to be fast tracked too.
we therefore wanted to get relief as soon as possible, given the stakes of the issues presented.
I guess I would have thought with the stakes that you would want to cross your procedural T's and dot the I's.
Your Honor, given the extraordinary importance of this case and the
There's
fact
an
that it's
extraordinary
presented,
important case exception to, I mean, it seems to me all the more reason to ask the district.
True. Yeah. Is there a very important case exception? Oh, so since this case mattered a lot, now the process and procedure doesn't fucking matter? Oh, I'm so sorry. I didn't know that your case was so fucking important that now none of that bullshit actually matters. Now we go to the extra. No, I didn't know that we were in fucking Hollywood right now. That we're just going to do shit however the fuck we want. Oh, okay.
Court for a stay if it's important. I mean, is the government now of the view that we should adopt as a ruling in this court that when it's extraordinarily important, but there's still plenty of time, you don't have to ask a stay from the court first or from an agency first?
Your Honor, we disagree that there was plenty of time, and we went to this court.
Yeah, more than a week.
More than a week. She named all the days of the week.
Your Honor.
Wait, that was a long pause. It sounded like I unpaused it late. No, that was a long pause. Hold on.
There was plenty of time, and we went to this court.
More than a week.
Your Honor,
One sentence.
Your Honor, to the extent that this court believes that exhaustion is important, we're happy to do so before the district court. We expect that we would get an almost instantaneous denial. If that's something that is...
Then get the denial. What do you mean? You can't just say, wait, they probably would have denied us. We didn't even fucking waste our time. We came to you first. Hello? What? What is original jurisdiction? Hello? You got to go through the process.
Holding up relief in this case, that's something we're happy to do.
All right. I had questions about your argument that this has to be done, that this relief has to be sought through habeas corpus.
Yes, Your Honor.
There are a lot of cases from the Supreme Court and this court recognizing, I mean, again, Clark is the chief one right under the Alien Enemies Act, that when someone is bringing a procedural challenge, that two things, a procedural challenge, you
Let's
don't
use two diagonal splitters. to draw from. What is a diagonal splitter?
Don't have to go through the ordinary individualized decision-making that you do for immigration challenges, removal challenges. That you can have class actions that bring challenges to the procedures by which removals are being implemented. And that's not a habeas claim because it's a challenge to procedures. And married to that is that not one of these plaintiffs, or as best we can tell, people in the class, is asking to be released from custody. And the Supreme Court has said time and again that when you aren't being asked to release from custody, in fact, they want to stay in the U.S. custody. No one's challenging the right of the government to detain them. But habeas is not the right vehicle. You've got Thurgasium, you've got Munaf versus Green. It's not the right vehicle. And in Clark, we allowed a lawsuit by an organization and 159 parties challenging application of the Alien Enemies Act.
Your Honor, I disagree with that for three reasons. First of all, the procedural right here that the district court derived in its order this morning essentially comes out of a string side of habeas cases. And so the right that the district court has divined here is clearly, to the extent that it exists, a habeas right.
No, it's a right to have procedures and opportunity in place, notice and opportunity in place across the board for everyone who's being removed, not detained, removed under the Alien Enemies Act.
Your Honor, I think two more responses to that. One is that the right at issue is being derived from habeas, and that's very important because it means that APA jurisdiction isn't available. Here's how this court addressed a very similar case in LeBeau.
What does APA jurisdiction mean? What does that mean? Wait, fuck, did I just full screen? Sorry. APA jurisdiction. Diagonal splitters are yet faster than... This looks like autism. Okay. Oh, the Administrative Procedures Act. Sorry. Okay.
Versus Christopher. It said that the key to plaintiff's inability to pursue a suit here is jurisdictional and rests merely on the availability, not the actual seeking of habeas relief elsewhere. This court then further went on to explain that, quote, the availability of a habeas remedy in another district ousted us of jurisdiction over the alien's effort to pose a constitutional attack to his pending deportation, end quote. And so what I think you have here is the district court found a right derived from habeas cases. And the fact that it sounds in habeas means under LeBeau versus Christopher, it has to be.
I'm very confused. I'm very confused because we've got plenty of cases, and the Supreme Court's got plenty of cases that say when you're not asking for release from custody. Munaf was someone who said, I'm happy to be in the U.S. custody. Please don't release me to Iraqi custody. And that's right. And that sounds very similar to here. We are not, probably not happy, but they're not disputing the right of the U.S. to detain them. What they are disputing and challenging is the capacity of the U.S. government to release them.
For detainment, remember, for detainment, you don't have to have any charges brought against you at all. A cop can arrest you without ever telling you at all what you're being charged with. The habeas corpus part, or the right to have charges read to you, I think applies. I want to say in most states it's within 72 hours, I think, is your right to an arraignment. Otherwise, you have to be released after being arrested. Sorry, I'm saying detained, but I truly mean arrested. But for you to be held for more than like a day to 3, I don't remember if it's the same in all states. I think it's 1 to 3 days. You have to have charges read to you. Otherwise, you have to be released. This is what we're talking about. You can't just be held indefinitely with no trial or no charges read to you.
To Salvadorian jails without any advance notice and due process of whether they even qualify under the proclamation. That's not release. And we have said time and again, and the Supreme Court has told us, which is much more important, that's not habeas. Whether it's arising in the immigration context a war powers context, like the war in Iraq?
So can you be detained in jail or are you arrested without charges? I believe you can be arrested without charges in the United States, but they have to do an arraignment. They have to read your charges to you within, I don't know if it's like 1 to 3 days or something. But I believe you can even be arrested without being, you're not formally charged with a crime, or you don't have to have like charges read to you. I'm 99% sure of that. 94% sure of that.
It's not habeas, and that is addressed through the APA.
Your Honor, I disagree with that. I agree that Munaf is an instructive case, but I think it cuts the other way. Here's how the Supreme Court characterized it, and I believe this is how you were characterized as well. It's like, here the last thing petitioners want is simple release. They essentially wanted to stay in custody, but nonetheless, I believe it was Part 2 or Part 3 of the Supreme Court decision in Munaf held that habeas was available, and then in Part 4, it held that habeas petition failed on the merits. But the first issue presented was whether or not you could bring habeas in such a circumstance, and the answer to that was yes. And then
The Supreme Court held.
I thought detainment requires reasonable suspicion and arrest needs probable cause. That is true, but reasonable suspicion and probable cause doesn't have to be spoken to or communicated to the person being investigated. Generally, yeah. Now, for a search warrant, I think a search warrant does have to be presented before you do a search of something, but...
It again in Farasagian. Sorry if I'm saying it right. Farasagian, right? Filed habeas petitions in an effort to block their transfer to Iraqi authorities, rejecting this use of habeas. They rejected it.
They rejected it on the merits, but they didn't say that habeas wasn't available. And I think Farasagian is a different case. That actually was a challenge to the procedures, which doesn't sound in habeas. But here, it does sound in core habeas, and let me explain why.
No, it's not. It's a procedure. You don't have any procedure, at least as of Saturday when the TRO is issued.
Also, this is a super fucking nerd, whatever, legal argument, bullshit or whatever. But remember that on a legal side, I mean, nobody actually knows, anyone cares about this. But like on the Trumpel side, the whole argument against Section 3 of the 14th Amendment, the idea that you couldn't have somebody into elected office who'd been part of an insurrection or whatever, the whole argument against that was procedural, by the way. Even in the Supreme Court shit decision, they ended up supporting it, supporting basically the destruction of the 14th Amendment, Section 3. They basically supported that on the grounds that the procedure would have been really hard to do. So, that was all done on procedural grounds. Now the government's like, well, procedure doesn't fucking matter. Like, we just want to fucking do this shit. Who cares about procedure? Like, that doesn't matter. What matters is the fact that it's war and we decide everything during war, right? Now they wrap themselves in procedure. Before, right, when it came to the 14th Amendment, the procedure, who the fuck cares, or not rather who the fuck cares, but rather like the fact that the procedure is so complicated in and of itself means that this whole thing needs to go away,
At the time the TRO is issued, and we'll talk about the second one because I guess the sort of absorbed the first one. At the time it issued, there was no procedure in place, no advance notice sufficient to allow anyone to seek habeas. And there was nothing in the proclamation or in regulations or processes, doesn't have to be formal regulations, but processes adopted by those implementing the proclamation to give any such process. That's the argument. That's the issue. And that was not released. That is request for injunctive and declaratory relief due to failed procedures that the Supreme Court has said time and again do not constitute, cannot be brought in habeas.
I would donate this guy fucking $10 million if the government would argue, ma'am, you have to understand, we were given a mandate by the American people to do whatever the fuck we wanted. So all this shit about Gabius, no one gives a fuck, okay? We were elected by 83 million Americans to do exactly what we're doing right now. Are you going to stand between us and them, ma'am?
Because you don't want release.
Your Honor, I disagree with that on a number of fronts. First of all, again, on page 41 of the Saturday transcript, it's very clear that the basis of the TRO on appeal here was a frontal assault on the president's determinations that various statutory preconditions of the AEA had been satisfied.
Okay, but if we don't read it that way, if we read it as also being grounded in these claims for a process.
Due process to
And that's
determine
why
if
they
you
came in so
qualify.
fast.
Yep.
So we get away from those issues. They want declaration or injunction against TRO to start with. Declaratory or injunctive relief against removal
Your Honor, the fact,
on a failure to adhere to
Your Honor.
due process by those implementing the proclamation.
Your Honor, I disagree for two reasons. I think, first of all, their complaint still clearly includes those facial attacks on the sufficiency of the statutory preconditions. As long as those are in there, those are an attack on the government's ability to exercise a scintilla of.
This is so boring. Nobody is challenging, in this case, Trump's ability to, well, actually, I shouldn't say that. They are challenging, I guess, like who he can declare war against or whatever, but this is fair. Because again, with the government's reading of this, the government can basically declare war on anybody or anything and then just start deporting people. The idea that Tren de Aragua represents the government of Venezuela, therefore you can just start deporting Venezuela, that's on its face also an absurd argument. Although I don't know how important that is, I guess, overall to what the people on the complaint are asking for here. But
Custodial authority over the bodies of plaintiffs in order to either detain them or to remove them. And so as long as those are in the complaints, those sound in core habeas and cannot be brought here and would require transfer to another district or dismissal. But second, I think that the procedural one still challenges fundamentally in core habeas. It says you may not do anything to me under the AEA until you satisfy these preconditions. You are utterly without power to do so. I mean, that is the same sort of core habeas as asserting that a conviction is wrong because procedural requirements in a trial were not followed.
But convictions can literally get thrown out if procedure and trials aren't followed. Unless I'm totally misunderstanding what he just said there. I don't understand that statement at all. Can't that exactly happen? We saw Alec Baldwin's case get tossed because of fuck up by the prosecution on a turnover evidence. I want to call this a Brady violation. Is that what it's called? Or is it something different? Maybe I misunderstood. I don't know.
I mean, that is the same sort of core habeas as asserting that a conviction is wrong because procedural requirements in a trial were not followed.
No, I don't think that's the same at all because people don't go through a trial in this country without getting the gold standard of due process.
That is
and
true,
that was not happening here. I think that's a false equation. The problem here is, right, that they are challenging implementation of the proclamation in a way that never gave anyone a chance to say, I'm not covered. And if your argument is he didn't have to do that, it's an intrusion on the president's war powers, the courts are paralyzed to do anything, then that's a misreading of precedent. It's a misreading of the text of the Alien Enemies Act. And that can't be an unlawful intrusion on the president's powers. It just can't. The president has to comply with the Constitution and laws like everybody else.
On that, we certainly agree, Your Honor. I think that what has occurred here is that, aside from the shifting injunction issue, is that the district court has derived a right from habeas and then used that to create a non-habeas
right. Derived from habeas.
The pre-deprivation thing, the right that he found in his this morning's order comes entirely out of habeas cases, and that's how it has to be asserted.
Sorry, so your theory is that they don't get to challenge it until they're in the Salvadorian jail? They don't get a pre-deprivation? I don't understand.
Wait. I got it. You should say, actually, ma'am, the 5 people on this complaint have already challenged it before they've gone to El Salvador, right? Bring up the 5 again, the magnificent 5, do it.
And the pre-deprivation, they're already in detention. So if I'm understanding you right, are you saying that they don't have a right until they're removed from the United States in U.S. custody?
Bring up the 5.
To challenge?
Please.
This isn't.
Yeah, it's fucking
This
retarded.
isn't
It's
an McKen
retarded.
situation.
It's retarded. Say it. Say it's fucking
There's
retarded.
nothing like that. They're challenging an immediate removal, not under the Immigration and Nationality Act, but under the AEA without process. So your theory is they're supposed to do it from the Salvadorian jail?
No.
After the fact?
These 5.
No, Your Honor.
The 5. The 5.
It's that
the 5.
whatever right there are sound in habeas, much like Lebeau, where the challenge was to a non-Title VIII removal. That sounded in habeas and had to be brought as such, and the availability of habeas meant that the district court was ousted of jurisdiction to hear other claims. That same logic means that the TROs issued below are invalid and should be reversed or
The
dissolved.
Supreme Court in McNary versus Haitian Refugee Center, Reno versus Catholic Services said, we don't care about jurisdictional limits on claims that are supposed to go through ordinary statutory processes like Title 8. When you are bringing a class-wide action for injunctive and declaratory relief about procedural failures, that would seem to fit this case.
Your Honor, we disagree. I mean, I think to the extent that it's procedural, it sounds in habeas, and hence this class does not operate properly.
Not procedure. An individual can't complain about that. They needed to do it class-wide because people weren't going to have the opportunity to file a suit and bring a procedural one. On the individual determination of whether someone's a member of Tender or Wagwa, that's a separate question. But for injunctive and declaratory relief that does not seek release from confinement, the Supreme Court has said time and again, that's not habeas.
Your Honor, I disagree. And had they brought this case in district court in Texas, they could have raised it as both APA and habeas. They instead elected to choose a different court. And that meant that that came with all the jurisdictional limitations of that particular court.
It's a venue issue for habeas, not jurisdictional. I mean, that doesn't affect the jurisdiction of the district court. That's a venue issue. Whether you
Because it's jurisdiction, I think, has to do with who can hear a case. Venue just has to do with like where the trial or the case is held, basically, but within a jurisdiction. So you have multiple venues within a jurisdiction. So whether or not they went to the Southern District or whatever the fuck District of Texas or the Southern District of New York or a DC court, it doesn't matter. It's the same jurisdiction. So anything that would apply in one jurisdiction, I would imagine, would apply in another jurisdiction insofar as federal level stuff is concerned. So I don't know why you brought up unless you think some circuit or some federal courts are, I don't even know what the point of that was, why you brought that up.
That's a venue issue. Whether you're suing the custodian.
Your Honor, it's not subject matter jurisdiction, but it does go to the authority of the court. And in the Rumsfeld versus Padilla, the Supreme Court did say it was jurisdictional, not in the subject matter jurisdiction, but it's not just a mere venue rule. It cuts to the core authority of the court to grant habeas relief.
As long as it can be served with process is the test, right? As long as the defendants can be served with process, then we've got jurisdiction. It's just a venue argument. And an important one, I'm not diminishing that at all. Courts frequently enforce the venue requirement that you sue the right custodian, and that custodian is by definition in the district where the person's detained.
Your Honor, we certainly agree that it's case dispositive. I think it's not, venue may undersell how important it is. Supreme Court has characterized it as jurisdictional in the sense that it goes outright to the authority of the court and not merely a sort of, steering things to where they might be convenient to be heard. It's something more fundamental than that. But in any event, that probably doesn't matter because I think we're agreeing that if venue is improper or for habeas, like the court is just simply out of authority to do it.
All right, we'll give
Is
you
this just one side, or is did the plaintiffs make their
a couple
argument?
minutes to reply.
Okay.
Thank you, Your Honors.
Mr. Billard.
Good afternoon, Your Honors. Lee Galern from the ACLU for plaintiffs. Time permitting, I want to address why this court, the courts absolutely have jurisdiction to review whether the statutory predicates to the Alien Enemies Act have been met and why they haven't been met here. But I want to put that aside for the moment and sort of jump into the conversation you've been having with the government. First, I just want to put one thing to bed. The district court has not said anything yet about whether he intends to try and bring people back who were already sent to El Salvador. The district court is very concerned, understandably, that his order was violated but he is trying to get to the bottom of those facts. He has not made a determination of whether his order was violated, much less what he would do as a remedy, whether he would try and order the individuals back. So I don't think that issue is before this court. And so I think that's a red herring. The second thing is that I think the government now, and we in the government have sort of joined issue. At a minimum, it seems like the government is grudgingly admitting that after Ludecky in footnote 17.
Wait, I'm sorry. Somebody said the fact that our government is dealing with 2 big hearings at the same time between the leaks and this, something new and crazy every day. Not 2. There are multiple TROs that have either been in full violation that the government is now like working to come into compliance on, because the Doge one they lost as well, about whether or not, I think it had to do with the USAID being shuttered. I think it was USAID, right? That they appealed that one all the way up to the Supreme Court and they lost. So, I mean, like, there have been multiple TROs that have been issued towards the government telling it needs to fuck off with its behavior. Yeah.
In particular, that there must be ability to contest whether you fall within the act. And so now I think it's a question of how that's going to go about
Well, within
happening.
the proclamation, not the act.
I'm sorry?
Within the proclamation.
Well, yes, within
Same
the
thing,
proclamation.
right,
And so the district court has said very clearly he wants to figure out how that would work. He has asked both of us. Neither us or the government had a clear answer for him at the moment when he asked it, the hearing. He intends to get to the bottom of it. But I think what it means is that even if this TRO is appealable, and we don't think it is, but even if it was, I think it's the easy ground to affirm the TRO is that there was no process. And I want to be very clear about 2 points. One is that the process, to the extent the government says you can have process, that's illusory. People were designated TDA without any advance notice, rushed to Plains. We will put into the district court the piece of paper that individuals are getting that specifically says you are not entitled to review. So there is a lot of factual development left to do in the district court. Judge Boasberg is working extremely hard and extremely quickly, but I think this court would want that factual record. And I think that's one of the reasons that
Boasberger is the guy that's been issuing the angry orders saying that the government's been fucking around. Boasberger has also been assigned to the government's case relating to, I think, this the investigation to this, just the recent Signal chat thing as well, I think. Boasberger has also been assigned to that one. So, yikes.
TRO is not appealable. This is not, yes.
Could you have done everything in a Texas district court that you did in this district court?
Perhaps, Your Honor, but I don't think it was necessary. There's absolutely no question now that the law is that this kind of challenge where you're not seeking release doesn't have to be brought in habeas. It can be brought by APA. It could be brought in habeas, but it doesn't need to be.
Well, so I want to get to that in a minute. But I think the common ground that you've just sort of asserted and that the government, you said, kind of has begrudgingly given, it's really significant common ground that I think has been lost in some of the briefing and some of the transcripts. You could have filed the exact same complaint that you filed here in Texas District Court. The government is not contesting that each plaintiff could have gone before an Article III judge and said, I am not a member of Trinidad Aragua, so I'm not covered by the proclamation, so I can't be removed. And could have done that. I think you would both agree that the plaintiff could have done that with the habeas petition. I know you push back and say it doesn't have to be a habeas petition, but I think you would agree that everything I just said is true and that it could have been done through a habeas petition. Is that right?
Well, Your Honor, yeah, I mean, I don't think it's insignificant that it didn't have to be by habeas and that we have to, what plaintiffs, we can choose our venue, but I want to address your question specifically. We could have filed a class, perhaps, a class habeas, if that's what you mean, but we certainly weren't looking just to get our 5 individuals from being sent to a Salvadoran prison.
Right.
So this would have had to be a class. If the government is suggesting that we could have gone in there for every individual, absolutely not. We did not know who has been designated. This has all been done in secret. The president signed
I
it.
get,
Yeah.
I think you're going beyond what my question was.
Okay, I
And I'm not sure
apologize.
the government would agree that you can certify a class in habeas.
Oh,
I'm not sure I
exactly.
would agree with that either. It's that more of an open question that we would need to look into. But on Saturday, early afternoon, you asked the district court to enjoin the removal of the 5 named plaintiffs. The district court did. A Southern District of Texas court could have done that as well, right?
So,
I just-
yeah, I just want to factually,
Okay.
when we filed it at 2 in.the morning, whether it's Friday night or Saturday morning, the district court in the early morning enjoined the 5 named plaintiffs. The class papers had already been filed with the complaint at 2 in.the morning, both complaint for declaratory injunctive relief and habeas, with class papers seeking a TRO for the class. The district court then held a hearing at 5 p.m. to decide whether his TRO was going to apply to the whole class. Absent a class TRO, we would have had far more people sitting in a Salvadoran
I get
prison.
that, but my question is not about what the district, my question for now is not about what the district court did. It's just about whether everything the district court did, which you just described, and I was off by a few.
Can somebody explain? So I'm curious. There obviously is a big legal significance here that I don't understand. What is the significance of them filing or not filing it in the Southern District, or I keep saying Southern District, whatever, a district court down in Texas? Is there a reason why they're asking this so much? Like, you could have filed this down in a federal court in Texas instead of up in the DC court. Is there a reason why that matters?
A few hours, but it was, Saturday.
Right.
It was a long Saturday. Everything that happened that the district court did, a Southern District of Texas district court could have done.
Assuming they would,
There's a general rule that you have to file habeas corpus petitions in district where the person is being held. Okay, sure. Well, wait, you say district, but if this is a federal thing, isn't a district, couldn't any theoretical district court hear that? Number one, and then number two, they're not doing a habeas corpus petition, right? Aren't they doing a challenge via the APA?
do it as a class?
So then,
Yes.
So I think that nicely tees up where the real dispute is, because you're not saying you couldn't have done all this in Texas. And the government is saying, A, this has to be habeas, and habeas has to be in the district where the detainee is detained. And that would be Texas. So I know you disagree with both of those things, but I think
Gotcha. I understand. Okay. So one of the ways the government's trying to Hail Mary this is saying this is a habeas corpus petition, and that properly would have to be heard in the district where, in the particular district, I guess, wherever the person was being held at. And they're arguing this is an Administrative Procedures Act challenge. Actually, it doesn't have to be a habeas challenge. Okay.
the government, I think there's some common ground there.
There's common ground now that there has to be process, although I still see the government accepting it grudgingly, because this whole pre-deprivation thing, we were talking about people being sent to El Salvador, one of the worst prisons in the world, incommunicado. They're essentially being disappeared. The president of El Salvador has now said maybe they're going to spend the rest of their lives there. The government has provided zero ability to bring habeases. It would have had to have been done by a class, and to the extent the government's saying going forward, we'll give you process, I have not heard one word about them giving us advance notice.
At this point, everyone who's detained can bring, would you say that at this point, everyone who's detained can bring a habeas petition?
That's not the issue, though. The issue is that the government didn't provide notice before. They are now, but maybe in the future, again, then they won't. That's the issue, right?
Because of the TRO by Judge Boasberg
Yes.
only. And that is even assuming, and I don't think this is true,
That they followed the TRO.
everyone has been clearly designated, that we know exactly who the government thinks falls under the proclamation. And therefore, if they didn't file a habeas right away, they could be put on a plane.
Exactly,
And so
without
I
any
certainly
notice
don't
at
think
all.
this is the way it would go about with individual habeases, you know, and
If the TRO were lifted, there wouldn't be a meaningful way to bring habeas.
I think the government's going to put people back on a plane immediately, just as they
Exactly.
did. The whole thing has played out in secret. The president is supposed to make a public proclamation. He signed it on March 14th. It wasn't published till the afternoon of March 15th. People were already being lined up to be brought to planes. So I think we're dealing with something that is illusory, and that's even if we accept that habeas can be brought. But
I mean, we know it can be brought because you brought it. You filed a habeas.
Oh my God! Is this the Trump appointed judge? The five have already brought it.
it could be brought by habeas, but it doesn't have to be. And I think we are.
Let's go to
Oh,
that.
I'm so sorry. I just want to full read out. I'm so sorry. He's not arguing that it can be brought. These five are brought. He's arguing about it being. I think he's arguing about it being a habeas thing versus an Administrative Procedures Act thing. Is what he's saying. I'm sorry. I think.
It could be
think.
brought by habeas, but it doesn't have to be. And I think
So
we are.
Let's go to that, whether it has to be.
Right.
And I think perhaps reasonable people can disagree about this. I think it's hard to get around LeBeau v. Christopher. The district court addressed it today.
I'm sorry, hard to.
LeBeau, I may be pronouncing
Yeah.
it
So
wrong.
that.
Can I just read from
Yeah,
the-
sure. I'm sorry, Your Honor.
Says, of course, the plaintiff's focus is not explicitly on their present custody. That's very similar to this case where you're saying, you know, we're not asking to be let out of detention. We're just saying don't transfer us to one of these other countries. Says, of course, the plaintiff's focus is not explicitly on their present custody. They claim the nature of the relief requested is different here since they have not formally sought a release from custody as in the habeas action. But, and the court goes on, we have rejected precisely such efforts to manipulate the preclusive effect of habeas jurisdiction. So I think that's a tough precedent for you where LeBeau was, as I understand it, was about to be extradited to Canada, didn't want to be extradited to Canada, could have filed in Illinois where he was detained, actually did file a habeas petition there, filed in DDC, and our court said, no, you can't bring this suit in DDC. You have to bring a habeas suit in Illinois to challenge not your detention, your transfer to Canada.
Yeah, Your Honor, a few things about LeBeau, then I want to sort of broaden it. LeBeau is an extradition case. The extradition has for 225 years had its own case law, but I think the key in LeBeau that the court understood was that they were in fact seeking release through the other habeas. And so it seemed a little bit like they were trying to circumvent the habeas. I think that's why it's different. But the case law is voluminous that you don't have to bring a habeas unless it's a core habeas challenge to release. And I just want to touch on Thursingham for a second, that Judge Millett brought up. Thursingham, the government walked into the Supreme Court and said the only time habeas can be used is when you're seeking release from detention. You can't challenge your removal. That was ultimately what the Supreme Court accepted. That was the holding. That's on top of case after case after case saying, if you're not seeking release, and I want to be 100% clear.
Okay, so the Hail Mary for the government, I guess, has to do with whether or not this counts as a habeas corpus thing versus just an APA thing. I don't know any of the processes or procedures in law. I've never read a case on this. I don't know the procedure or whatever. So I can't give any informed opinion on it. But it sounds like the counter argument that the plaintiffs are bringing up is that habeas corpus can only be invoked if you're seeking an arraignment, basically. But you can't invoke habeas corpus to seek release. You can't get out of prison by saying habeas corpus. You can only say, at least read me my fucking charges. And then we can go to the right to speedy trial and all that other bullshit. But I don't know who's right or wrong on any of that. I have no clue.
Here, no class member is seeking release. Judge Boasberg was.
And then the plaintiffs are arguing nobody here wants to be released from prison. No one here is saying that they're not seeking release from detainment. They're seeking having any charges brought against them at all. They want to have a type of arraignment, or at least, but not really an arraignment, a formal arraignment, but just some process or procedure or arbitration or something where they have a chance to argue their case, basically. Yeah.
Absolutely clear that his order will not stop anybody from being prosecuted, anybody from being detained, allowing anybody to be released, allowing anybody.
And I don't know the answer to this question. I tried to ask the government.
Yeah.
I think maybe they didn't know yet. you may not know either, and suspect you haven't talked individually with every one of your class members. But do you know if anyone is currently being detained under the Alien Enemies Act proclamation and not being detained under any other legal ground?
I don't know the answer to that. I suspect that most people, maybe all of them, are being detained under the immigration laws because they were in proceedings. I mean, the government is using the act to try and short circuit the immigration proceedings. And so I think what they have done is pull people out of proceedings and put them on the plane to El Salvador. So
your original complaint mentioned apprehension and removal, and you wanted to enjoin both. I understand the district court did not accept your invitation to enjoin apprehension, but that does suggest that you were worried there would be some class members currently at large in the country who might be apprehended under this AEA authority.
So, Your Honor, I think to the extent that that language is in there, it may be inartful, but we're 100% clear with Judge Boasberg, and he has been 100% clear. We are absolutely not trying to get anybody out of detention, stop anybody's removal, stop anybody's prosecution.
Were those people in prison before, as in convicted or even charged, or have they been picked up from the streets? Well, it sounds like they've done both. But it sounds like one of the things that Trump tried to do is he tried to take people who were already in proceedings, so they'd already been charged with a crime, maybe even convicted or whatever, and now by invoking this Aliens Act, he's trying to basically just say, listen, whatever your process or procedure is right now, it doesn't matter. You're already arrested. Get them the fuck out of here and ship them out. That's why he said short circuit the procedure. Yeah.
And I think that goes to the larger point. This is a very specific statute, a wartime statute dealing with a very specific problem. It does not bar any other authority for prosecuting or removing these individuals, much less have to do with anything about stopping ships in China.
Can I ask you about Munaf v. Garin? Because I do understand how you can read it to help the government here and you can read it to help you here. I think the government is saying the first thing the Supreme Court held there was there is habeas jurisdiction. This is someone who wasn't objecting to being held, but was objecting to being transferred from U.S. custody in Iraq to the Iraqi government in Iraq, and said, don't transfer to the Iraqi government. And the first thing the Supreme Court held was that there is habeas jurisdiction for that because he was an American citizen. And then said, in your habeas cause of action, you lose on the merits, right? Because we're going to respect the Iraq's kind of what they said is Iraq's exclusive jurisdiction to punish offenses against the laws committed within its borders. So we have habeas jurisdiction, and habeas is your cause of action. But with that cause of action, you lose on the merits because of Iraq's exclusive jurisdiction to punish offenses against its laws committed within its borders. And if that's how it's read, it seems like Munaf is a pretty good precedent for the government saying, look, if you want to challenge your transfer from U.S. custody to another nation's custody, your cause of action is habeas.
Well, I think two things about that, Your Honor. One is Munaf said you could do habeas. It didn't say you must habeas. And I think that's the difference in these core habeas cases. Whether you could bring it in habeas, you often can bring it in habeas, but then whether you must bring it in habeas. So we understand the Chief Justice to be saying in that case, I think it was fairly clear, the last thing you want is simple release.
Right.
And so I think that's why Munaf doesn't answer the question. And Thursingham, of course, is the most recent precedent from the Supreme Court.
On the not having to bring it as habeas, the district court understands your cause of action to be an APA cause of action. I think the government says this is a presidential proclamation. It's different than an agency proclamation. I think last time I was on a panel and you were the attorney, it was an agency proclamation. And you can bring it, we see every day in this court challenges to agency order under the APA. But if there's a challenge to a presidential order, the APA is not typically the vehicle for that. And Franklin v. Massachusetts says, at least as a general matter, it can't be. I think what you'll say is, at least on the individualized determinations of whether the class members are part of Tren de Aragua, you're going to use the APA to challenge decisions that are being made by lower level officials. To me, that, if true, just indicates that there's not the type of commonality for a class that you need in order to certify a class.
Right, Your Honor, so a couple of
Please.
things. One is, I think we cited multiple cases that say even where there's a presidential proclamation, you can challenge its implementation by the agency. But to your common question, our common questions are obviously first, whether the AEA can be used at all against a non-foreign government. But the second question is, are they entitled to process? So at some point, if there's individual determinations about whether you fall within the proclamation, those obviously will be all common. But the initial question that we're fighting with the government about, and they're still, I think, grudgingly only conceding it, is whether they're entitled to some process. They clearly have not been given process, but for this action, I don't think the government would be conceding what it had to concede.
What's the status of the habeas petitions in Texas, the ones that have been filed and that are ongoing?
Yeah, that's a good question, Your Honor. We've been trying at council table to find out a little bit about where they are. I think they're generally on hold. And those individuals, there were few habeas petitions, very few people who happen to sort of guess that maybe their person is going to be designated. But for the vast majority of people, they haven't been designated. I wanted to also clear up one point of confusion. The government keeps reading from the transcript at page 41 that the judge's initial TRO, I mean, the judge has obviously made clear this morning what his TRO is principally based on. But the judge's hearing transcript on Saturday night was very clear that he was also talking about process. And that's at pages 29 and 30, starting at line 25, Your Honor, where he was very specifically talking about process, and footnote 17 in Ludecky that said you have to be able to contest whether you fall within the proclamation. So
Sorry, finish.
yeah, no, I'm sorry.
I want to ask about, I guess this goes to some degree, I think it goes to the irreparable harm the government asserts.
Right.
And to some degree to maybe larger issues. And so the question I'm going to ask you is going to sound like I have some skepticism about what the district court did on Saturday. I want to preface that by saying we've had a week to look at this issue, and it's been hard. And the district court only had a day.
Right.
You know, about a decade ago, one member of this court, long before I was on it, talked about district judges having to deal with Guantanamo issues. So they were difficult and intricate and complicated and novel. And he said, even when this court might disagree with the district court decision, that disagreement is with respect for the dedicated work of the district court in these matters. That said, I'm wondering if you can point me to a district court TRO or injunction that survived appeal that stopped an ongoing, partially overseas national security operation in the way that this...
Probably not, but it's going to be the same argument as before. I can't give an example of something like this succeeding before, but like nobody's tried this before. There's a novel application of, what is it, the Alien Enemies Act? Is that what it is? Alien Enemies Act?
At the time, at least, did order planes to take foreigners from international waters to the United States.
Your Honor, so to start with, the order about him bringing people back, potentially bringing people back, is not before you. And I think there's a lot of factual development. And I don't know how much this court is aware, but there have been emergency proceedings almost every day. And I think the district court has not been pleased with how the lack of forthcoming attempt.
Can I just add that, though?
Yeah, and so, but that,
There's
yeah.
this declaration by, it says that he's been at the State Department since 1971. That's
Kozak,
54 years ago. My math is right. That's quite a lot of experience in the State Department. Now he's a career State Department official, head of the Western Hemisphere's Affairs Bureau. And he says that this TRO is, quote, harming the foreign policy of the United States. It comes after, quote, intensive and delicate negotiations with El Salvador and the Maduro regime, risk the possibility that those governments will change their minds. It gives them leverage for renegotiation. And he warns, quote, these harms could arise even in the short term. So, I mean, those concerns are ongoing. I understand that there are no longer planes in the air that are being ordered
Right.
to return to the United States with foreigners that the executive branch doesn't think should be in the United
Oh my
States.
God.
I guess just maybe from a 10,000-foot perspective, I thought about when Justice Douglas enjoined the bombing of Cambodia, but it didn't go very well. The Supreme Court reversed him in about 6 hours.
Bombing of Cambodia, bro.
I found a couple other injunctions that are somewhat analogous, but they didn't survive appellate review either. Can you, standing here, give us an example of a district court injunction that enjoined a national security operation partially overseas that survived appellate review?
Well, Your Honor, I want to push back on the overseas part because I don't think the order to return the planes is before you. So what we're talking about is not sending people, and that is
Foreign policy
straight
implications,
removal.
the
But
negotiations with
okay,
the Maduro
so
regime.
let me address that. So
Well,
yeah, I know.
I will not stop you from having time to address that, but can you just tell me what's an example of the district court enjoining a national security operation with foreign relations
Right.
implications? I think we could at least agree on that.
So I think for one thing, I would cite Boumediene with the Supreme Court saying there has to be habeas. I mean, the government could not have argued more strenuously that the court should not interfere and say that they're entitled to habeas while they're at Guantanamo. But to your point about the national security, I want to return to something that Judge Millett said. The government cannot take the position that it's an interference by this court on national security grounds to give people process. The Supreme Court was 100% clear
Yes.
in Ludecky in footnote 17 in multiple cases saying process. So for the government to say you're interfering by giving what Justice Frankfurter said in Ludecky was necessary as a matter of the act, and I don't even think he needed due process. He was ruling as a matter of the act. You have to be able to contest. The implications of not giving people a chance to contest it are extraordinary.
Yes.
I mean, every religious and ethnic group in this country has at some point been tagged as associated with a criminal organization. If people can just be picked up and sent.
Yes.
Mr. Galern, I mean, I just have to stop you. You're not getting an argument from this bench
Okay.
so far today against the idea that every single member of this class
Okay.
can have an individualized habeas determination in front of an Article III judge to say, I'm innocent. And I think I take your point about Boumediene and your point about Ludecky, but I think it's hard to answer some of our questions without mentioning cases that are habeas cases. Boumediene was habeas, Ludecky was habeas. And so it seems like in order to answer one question in a way that is kind of satisfactory for your position.
Well, that's because they were asking for release.
But you are asking to stop a transfer, and that is something that habeas has been used for repeatedly.
Yeah, but it's not. But it doesn't. I don't think just because habeas has been used to stop the transfer doesn't necessarily. Hold on. He's saying the judge is trying to say that okay, so they're arguing that this isn't a habeas case. The plaintiffs are arguing it's not a habeas case. It's an APA case. Why does this matter again? Is it just because then it changes which court they needed to bring it up in a federal court that was nearest where the facts of the case are? Is that the only reason why this habeas APA distinction matters? It's super hard to find any examples I feel like that are gonna help the plaintiffs here because it just feels like such an exceptional case, I guess. Like I don't even know what you would look to.
It could be used, but it doesn't have to be used. And we, of course, but I think, Your Honor, I want to return maybe to the very beginning of this appeal. We don't think there's jurisdiction over a TRO. I mean, you just had the decision in Dellinger. That's a very, very rare thing for this court to find that a TRO is appealable. And there are two preconditions. One is that it's a mandatory injunction not preserving the status quo. Judge Boasberg was explicit that he's simply preserving the status quo. And the other thing is that the harm can't be undone. You cited Mr. Kozak's affidavit. That's the last sentence in a 2-page affidavit, which says there would be harm, but then he switches to could when he's talking about the short term. And all we're saying is that
I think that we as judges don't know everything that the State Department knows.
Well, I think there's a reason why he switched from would to could in that sentence when he was talking about the short term. We're here asking that Judge Boasberg be allowed to do his work. And I think counsel for the government repeatedly answered questions to this panel by saying, I don't really know, there's not a factual record yet.
How do you just, on the question of whether this TRO is the type of normal TRO that can't be appealed or is the type of unusual TRO that can be appealed? We have this Adams v. Vance case from 1978. It says that you can appeal that TRO, and it called it an intrusion on executive discretion in the field of foreign policy. I mean, I know you maybe don't think that's what's going on here, but the government argues that that's what's going on here. So it seems like if you lose on the sort of merits of this argument, you should also lose on the is it appealable part here.
Well, I think, Your Honor, that Adams was very different because it was a mandatory injunction telling the Secretary of State what to do. And this is very different. It's preserving the status quo. And there was also a fuller affidavit.
I understand the planes are not in the air now, but it was not preserving the status quo when the planes were ordered to be turned around.
Well, Your Honor,
They keep focusing on that. Is it really the case that they couldn't have just landed and brought them back? Wouldn't that be a preservation of the status quo? Did they really have to just turn them around?
again, I'm not sure I have much more to say on that other than that is about whether a district court's order, a federal judge's order was violated, but he still has not made any determination, so it is not before you. In saying that keep these people on the ground, don't let them be removed under the Alien Enemies Act. This is an unprecedented move to use the Alien Enemies Act for only the fourth time in our country's history without a declared war. He's saying preserve the status quo until we can find all the facts. And I think what we're going to show in the district court is that many, if not most of the people removed had no connection to the gang, that the gang does not actually have a formal structure with members. We're going to put in evidence about what happens in a Salvadoran prison, that you could remain there for the rest of your life. We're going to put in evidence, hopefully, about what the timing was and who signed it. President Trump has introduced confusion about now whether he actually even signed the proclamation. So all we're saying is that Judge Boasberg is working very hard.
No doubt. Sorry, you can finish that sentence.
No, I was just saying
he's working very hard, and that he has had to move very fast.
And I think we're going to move on a preliminary injunction very quickly. And I think
I'm so curious, because keep in mind too, we're not even listening to like oral arguments for like an actual real case yet, right? This is just over the TRO itself. So no one is even close to having all the facts of the record yet too, which is also kind of silly for this.
for this court to sanction anything about what the government's doing, or even to say Judge Boasberg shouldn't have time to figure out what the process is so it's not an illusory ability to contest, without a factual record, I think that is probably short-circuiting the way the system should work. I mean, we're really talking about something extraordinary to name a gang rather than a foreign country.
Yes.
This was a wartime measure meant for war.
Let me just, in terms of irreparable harm to your clients,
Right.
in terms of El Salvador prison that you just mentioned, all the things that you've just that you've just articulated, what's your response to the government's argument? You can maybe do all that, but you just got to do it in the right court. And the right court is in Texas, not here.
Yeah, Your Honor, I just want to I want to answer that, but I just want to make one other point. The government seemed to be suggesting that this was about pre-deprivation, as if there wouldn't be harm if they were in a Salvadoran prison for a few days. But I don't hear the government saying if you win that habeas, we'll bring you back from the Salvadoran prison. So it's a little bit of...
This is why I was saying before that like the reason why this has to be granted for a TRO, the reason why the harm is irreparable is because let's say that they win the case and then the federal judge goes, okay, well, they won, so you do actually have to give those people hearings. Then the government could go, okay, well, we went to El Salvador and we asked them to give the prisoners back and they said no, so sorry, like tough luck. Okay, well, now you're fucked, right? They suffered a harm. You can't compel the government to go to war with another country because of like a federal court. Like they're just fucked. Like,
You know,
is that literally it? That they should be in another court? Destiny? Do they just want a Trump judge? I mean, somebody in chat keeps typing. I just don't know if this is true or not. I'm not accusing him of lying. I just don't know the answer. A guy in chat keeps saying that they were shuffling prisoners around to different courthouses to try to make it so that it could be like or to different jails to try to make it like a habeas case, so that it was confusing, like where any of these cases even had to be filed. I don't know how true that is. That might be true. It might not be true. I'm not sure, but yeah.
the question, I'm not sure I have more to say other than there is case after case, starting with the Supreme Court's decision in Prizer in the 1970s through Thurasingham, saying you do not need to bring a case in habeas unless it's a core habeas, meaning you are seeking release from detention. And Thurasingham was as strong as you can be on that. That, you know, was a case that I argued, and it was unfortunate because we were asking the habeas be expanded, but that's where it's ended up. And that just builds on multiple cases from this court and from the district court saying there's a difference between whether you have to bring it in habeas and whether you could bring it in habeas. And so, but at a minimum, I think Judge Boasberg is going to try and figure that out and decide what process, because if the TRO is lifted now, as Judge Millett pointed out, our people are on a plane. They're just on a plane. And so I think Judge Boasberg has done a good job of saying, here's an easy ground to say, if assuming it's appealable, here's an easy ground to affirm the TRO.
Why wouldn't 5 minutes after the TRO is lifted, why wouldn't your next move be to file a habeas petition in Raymondville, Texas, where they're being detained?
A class action? Well, we don't know that.
The 5 named plaintiffs.
Well, I mean, to begin with, we're looking not to just have our 5 named plaintiffs not end up in a
If you're
Salvador
right
prison.
that a habeas class action is possible, you could file a habeas class action.
Well, I want to also make this point. The government is doing everything in secret. We have no idea.
Yeah, the thing is that like the TRO, like depending on when they lift it, they could have like planes fucking ready to go. I don't know how what the filing looks like. Like, would they literally need attorneys camped out, like they're buying PS5s or, you know, NVIDIA GPUs? Do they have to be camped out outside the courthouse waiting for that TRO release or the TRO lift announcement so that they can run like super fast to file because the government's like ready to whisk these people off to planes immediately? Like, I don't even know what that process looks like.
If everyone's in Texas. So all of a sudden we see a plane leaving from Arizona and they say, well, you filed it in Texas. So I don't know if the government's asking us to file in.
Oh, that too. Yeah. If you're saying these are habeas corpus claims, right? Well, what if they've transferred these prisoners and you know where they transferred them to? And then all of a sudden you file your writ of habeas corpus, the TRO is the TRO gets stayed, so it gets thrown out. And then you file your habeas corpus now to save your people in Texas. And then a tweet goes out with Trump saying, we've sent these disgusting Tren de Aragua criminals out of this country. And you say they actually transferred them to Arizona. You didn't even know. And now you're just like fucked, right?
Every single district in the country, or whether they're going to specifically tell us where people are being designated and give us time to do it.
I mean, maybe, but the strangest place of all to file would be in Washington, D.C., where there's likely not a single person
It's not
detained
relevant.
under the
It's
AD.
irrelevant.
Well, the people are being, I mean, just as a factual point, but I don't want to dwell on it. People are being moved from every part of the country. So we actually don't know whether people were originally in D.C. because the government's not saying it. We know
There's a
people.
detention center in Washington.
Well, we know
D.C.
there could be in the surrounding areas,
where-
but I think that the proclamation is coming out of here. The agency heads who are enforcing it are out of here, and I think this is a fairly standard place to bring it. But unless, you know, we can't even begin to figure out where to file all our habeases, even assuming a class action habeas, if the government's not going to tell us who has been designated in every district they're in.
You know where the 5 named plaintiffs are held?
The 5 named plaintiffs are in Texas now. They came from all over.
I would think they could file a habeas petition in Texas.
Listen to what he just said, though. They came from everywhere. So do they have to start filing habeas on every single federal? How many federal district courts are there? Not circuit courts, district courts. Like, you'd have to do it in every single district in the hopes that you catch. I mean, what if they get shipped to Puerto Rico? Is the government allowed to fly them out of there? No. You guys are saying 13. I'm not talking circuit courts because aren't there multiple district courts per circuit court? Like, the 13 circuits encompass beneath them all the different, all the district courts of that particular, wherever the circuit is, right? Because you're not filing these habeas writs, you're not filing these in a circuit court, you're filing these in your district court. 94 district courts, okay.
And you could try to use those 5 named plaintiffs to represent a nationwide class. And I'm not saying you would get the class certified or you wouldn't get the class certified, but at least the court making that decision would be the right venue for the 5 named class members.
Yeah, I mean, Your Honor, to begin with, once we're doing that, why Texas versus D.C. just because the 5 named plaintiffs happen to be there at the moment? I mean,
Rumsfeld v. Padilla could have argued this. I mean, why? What was the?
well, because those are,
You could have argued
yeah,
this.
I mean, those are,
You're supposed to file habeas where you're detained.
well, only if it's a core habeas. I mean, the immediate custodian rule applies only where you're seeking release because you want to be where the district director is. Your Honor, I may have sort of said what I can say about the core habeas. I think there's just too much law now to backtrack
There's such
on
a
that.
thing as a habeas class action?
The Supreme Court has ruled on the merits on habeas class actions. So, but it's an open question. And so if we went there and only had habeas and they said, for reasons unrelated to this case, we're not going to allow a class action, then I think our people would be back on a plane,
And then,
El Salvador.
how many people do you represent right now?
The fuck?
Your Honor, I wish I knew. The government will not tell us who
You
they've
represent
designated.
more than the 5 names.
Oh, absolutely. It's a class. And
Every one of those is your client. that's in
yes,
the class.
absolutely, Your Honor.
And so every one of those would need to have you file a habeas action.
Thank you. Yes.
If you can find
Yeah. And how many
where
courts?
they are and what district to do it in.
Yes. Yeah.
It's
Yeah.
Absolutely.
Immediately.
And then going forward, we'd have to know,
It'd be
the government has
ridiculous.
said they're going to continue designating people. And, just to the point of, I get that we're now at a point where the government or this panel is not saying it's in some venue you can contest. But it's really an extraordinary thing that's happening because people were rushed out, as Judge Boasberg said, and story after story is now coming out that people had nothing to do with the gang. And so I think we're looking at people now who may be in a Salvadoran prison the rest of their lives. And I think that's really the problem. And incommunicado, families can't reach them. There's no way to reach them. And the government wants to continue doing it. And I don't, when Judge Boasberg said, well, how would the process work? And, will there be pre-deprivation? The government didn't answer. And I hear the government also bringing up pre-deprivation again. So I just want to be clear that right now, as this is moving so quickly, I think Judge Boasberg has said, at a minimum, under Ledecky, the implementation of this proclamation cannot stand. And for that reason alone, I think the TRO has to be affirmed. We're going to move on a preliminary injunction. It will be back here, no doubt, from either
What are you
side
moving
on
on
a
your
full
PI?
record. I'm sorry?
What are you moving on the PI?
We're going to move in a couple of days, Your Honor, and we're trying to just gather as much facts as we can. Family members are seeing the videos of the harsh treatment men received when they got off the plane. They're alerting us. They're alerting us because they think their men have disappeared from U.S. detention facilities and they think they may be in El Salvador. We're also going to put in expert declarations about how the TDA gang works and that there's actually no formal membership. So figuring out who's part of TDA is very, very difficult, and a number of other factual developments. I would think this court, if it's going to rule on such an extraordinary issue, only the 4th time in history the act is being used, will want that full record.
And then I just had one other question. So Judge Walker has noted the difficult issues about the airplanes and stuff,
Right.
that sort of mess that was happening on Saturday. The TRO, the written TRO says nothing about that. It just says
Right.
enjoined from removal. And I know that there's a bit of a kerfuffle in district court about those oral directions, and the government's position is those did not bind it. I think your position is that they did. So do we have to, if we were to be concerned about,
Are there multiple judges in here? Yes. Most, probably every circuit court. Circuit court is your first court of appeals for your federal courts. Every circuit court is going to have multiple judges hearing these things. I'm almost positive of that. There's 3 in this one.
TRO at least is applied to directing airline flights out of U.S. airspace, but people still in U.S. custody. Do we have to resolve that question of whether the oral language he was using at the hearing was itself part of the TRO?
I don't think so, Your Honor, because I understood that the district court to be sort of having 2 orders. The primary one was about going forward. He wants this enjoined so that and the other part was, let's try and stop the harm from occurring, so let's turn the planes around. Now that people are in the Salvadoran prison, the judge recognizes that the first step would have to be, was the order violated? The government says it wasn't violated because the planes were out of U.S. airspace, and there's a whole contentious thing going on. So I think it's
I thought they said they now agree that they were bound by the oral. I thought they said that they were only bound.
They're still pushing back on that as well. I think Judge Boasberg has been fairly clear that he thinks the oral order was just as binding. But I think the question really has not been resolved in the district court. Judge Boasberg is first very meticulously going to try and find the facts about whether his order was violated and only then decide if there's a remedy. But he's certainly not going to do anything before he finds the facts. And I think it would be premature for this court to get into it because we're talking about the government potentially deliberately violating a federal court's order. And so I think it would be best to allow Judge Boasberg to find those facts. Certainly the government, if he was to order them brought back, could come back up here. I can't imagine Judge Boasberg not staying that particular part of his hearing of his order if he ever got to that.
Mr. Gallant, just a question about the timing of us deciding this stay motion. I know the government wants us to do it quickly. Do you see sort of the fairness of us deciding it fast enough that if the Supreme Court wanted to reverse us, they would have an opportunity before the TRO runs out?
Your Honor, but leaving the TRO in place?
Well, I'm not saying whether you'd win or lose, so I know you got. I'm sort of asking you behind veiled
Right.
ignorance.
So what I would say is, Your Honor,
I do think,
obviously we
especially
would.
as long and as eloquently as you argued about your client's, right to be heard in court, I think maybe you would say the government, as a matter of fairness, ought to have a shot at the Supreme Court if they lose here.
No, come on, for a TRO.
If that were going to happen and you were going to rule for the government on this, then I would hope that Your Honors would give us time to seek a stay from the Supreme Court without allowing everyone to be put on a plane to El Salvador in the interim. But I would urge this court to allow the district court to just finish its ruling.
I mean, if we're going to rule for you,
Go ahead.
do you see the benefit of us doing that very quickly so that the government can get to the Supreme Court fast enough?
I will leave that to Your Honors, whether you think that's.
You don't have an objection.
I mean, we would prefer that you deny the stay request and send it back to the district court, and I don't think you need to rule quickly. I mean, I just want to leave with one point.
Real quickly if we're going to rule against you.
Right,
and
well,
real slowly
exactly.
if we're going to rule for you.
Exactly. I just want to leave the court with one point. If the government is going to stand up on reply and admit that under Supreme Court precedent, people have to have the ability to contest, and that that's a matter of Supreme Court precedent of the decade, the statute, and if you want to throw in due process as well and about the implementation, then it's inconceivable to me how they can say this is an intrusion on national security, because they themselves are saying, yes, at least that part of Judge Boasberg's order must stand. And so that certainly can stand until there's a preliminary injunction ruling. But I just don't see how the government can continue using this broad rhetoric about intrusions on national security if they're conceding that Judge Boasberg is right, as at least our secondary claim that there must be process, even if he was not willing at this point to rule on whether the Alien Enemies Act can be used at all against a non-foreign government.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors.
Mr. Ensign, why don't you take 5 minutes?
Your Honor, I'll be very brief. Just two very quick points.
This guy's a
I believe opposing
fuckhead.
counsel
Fuck
said
him.
expressly that this case could be brought in habeas. Under this court's decision in LeBeau, which I think I mispronounced earlier, that very clearly means that it must be brought in habeas. That is not in a distinguishable context. That was brought
It
by.
involves something that couldn't be brought under the APA at all, extradition. That's not this situation.
Oof, shut down.
Your Honor, I think the same.
Extradition is its own body of law.
It does have its own, but it is the same context of a person using habeas, or in that case, actually using it in a different court. But the fact that habeas was available to challenge a transfer to a foreign country meant that because habeas was available, it was available in habeas, it must be brought in
Long
habeas.
before Munaf versus Green and Thursagian. And Munaf versus Green was also, the court recognized that there could be habeas and that it could apply to someone in foreign lands under held by a multinational force in the middle of a war, but American citizen would still have the right to bring a habeas, and then just said that you can't get this relief of protecting you against transfer to another government in habeas. That seems to be, and that did not involve, that was detention issues and transfer issues. It wasn't extradition, which is its own body of law and just sort of inapt in this context. And there's no APA option there. There's definitely an APA option here. That's the point of Munaf.
Your Honor, I disagree both that LeBeau and Munaf involved challenges to attempted transfers to foreign countries. In both cases, the court said, though, in Abu, the court said that has to be brought as habeas, and because it could not be brought as non-habeas. And in Munaf, the Supreme Court said that can be brought in habeas. That was the first question presented that the court resolved by answering in the affirmative. And then under Abu, that means that it must be
Habeas is
brought.
available to someone named Munaf in this foreign situation. I mean, talk about
Okay.
interfering.
Are there any interesting things? If this is what he's leading with, I'm guessing this is empty. Okay. So the judgment that these guys issued from the Court of Appeals, the judges that we just listened to, in one day, because this was, when did they hear these oral arguments? Oh, this was 2 days ago. So in about a day. They did not stay the TRO, meaning the TRO is still live. So now what? Are they going to appeal this one to the Supreme Court as well? Or we don't have to read through all this, but TRO ultimately upheld by Circuit Court. Review of the Israel dossier on Hassam Shabbat Gazan journalist just targeted and killed. Don't you still meme that journalists aren't targeted? I don't care. For pro-Pally people, like if you take the worst and most retarded interpretations of everything that I say, then yes, that is what I say. So whatever you're linking, you are correct. Okay, thank you for educating all of us.
Would have been apt in this context. And there's no APA option there. There's definitely an APA option here. That's
Okay, you said go to 144.39 on this because we didn't get that far because we got bored. 144.39.
Nothing preventing these five from filing
not
habeas
my
action.
question.
Right.
My question again, there's a chance, reasonable time to file habeas petitions. Is that correct?
Your Honor, I think, as we've discussed right now, there's nothing preventing these five from filing
That's
habeas
not my
action.
question.
Right.
My question again is, if we were to grant the relief you request, would the government consider it necessary to allow time, notice, and time to file a habeas petition before removing people under the proclamation? Or would it, anyway, that's A, or B, is the government's position that it could immediately resume mass removals of these 5 named plaintiffs and the class members immediately? A or B? If you've got a C, you can tell me a C.
Your Honor, I think it's B, that we take the position the AEA does not require such notice, but that certainly in this period, these 5 plaintiffs could bring habeas claims right now and are electing not to do so. They could bring it in the correct court, and they've identified no obstacles to doing so.
There's a whole class before us. You haven't moved to vacate the classification. I don't know why you keep talking about these 5 people. We probably got.
Wait, what the fuck? You're okay with plainclothes cops who don't identify themselves arresting people? Let's say that you thought there. Okay, I'm about to ask a question. I can already see where this whole conversation is going. Let's say that there's a person that you think is either a flight risk or potentially violent. Do you think that police officers or some type of authority should have the ability to arrest that person in plain clothes, so as not to give themselves away beforehand? Oh, someone said they did identify themselves. They showed their badge. Okay. Like, there's no problem conceptually with them not being in like fucking giant SWAT vests or whatever. And I guess if they did show themselves, then it's even less of a thing. It just comes down to whether or not people just want to say every arrest now is bad. Because but I don't do that here, okay? If like there are other channels to go and do that on. I don't think arresting people is bad, okay? Now, if there were no good reasons to do it, then you should be mad at that, not out of a video of somebody getting arrested.
Class before us. You haven't moved to vacate the classification. I don't know why you keep talking about these 5 people. We've probably got hundreds of people before us, and I'm asking about those hundreds, including those 5. And as to them, I understand your answer is B. The second we vacate, if we were to do that, people are lined up and put on planes without notice or time to file for habeas. Even though the government agrees that decision, they have a right to have the decision made about whether they even qualify under the proclamation.
Your Honor, if the TRO is dissolved, the government believes there would not be a limitation and that the statute does not require such notice.
Does the government have any obligation with a class certified to notify council as to where these individuals are that are being removed, and so they even know which jurisdiction
Nope,
to bring
he's gonna say
a habeas
nope.
suit in?
Your Honor, I don't believe that plaintiffs have
Correct,
sought such relief. I don't think the district court has ordered it. And so,
Not notice. It's not notice. And it seems it's the government here that says you got to file habeas actions. The whole solution here is habeas actions. Let's all have habeas actions.
But there'd be no
So
way
it
to
seemed a
do
bit
it.
rich for the government to say, "Well, we're not going to."
That we're not going to give you notice that we're going to arrest you, and we're not going to tell your lawyers where you're being held. So how could you even do habeas?
Tell you where they are or where you need to file or give you time
Yep.
to file at all.
It's a joke argument. And the
Your
government
Honor,
doesn't
they
believe
certainly
it.
know where their own clients are and they're refusing to file
they
in a proper
don't.
How
court.
could they know? You literally just said they have no obligation to notify any of them, and they have no obligation to give notice. Do we need to listen to this? I guess it's 5 minutes more, but this is so stupid.
I don't even know how many are in this class.
As-
You can talk about 5. They represent way more than 5. I don't understand why we're just talking about 5. That's
Because he's running around his house.
class action.
Your Honor, they could certainly file in habeas. They seem to care about their
They
form
can't file
more
in
than
habeas
the...
unless they go to the right jurisdiction.
District.
I absolutely agree with that premise, Your Honor,
If
which
they
is why
don't
they
know
need to
where they
file
are,
in Texas.
And the government won't tell them.
They know where at least some of them are, and they're,
They know where at least some of them are.
That's no.
they're affirmatively refusing to bring habeas in those jurisdictions.
And there's no reason they've declined. They've made a choice not to that's supported by an awful lot of precedent. But that's not the point. The point is you must know how many more people are in this class.
Your Honor, there is a declaration that provides the estimate. I believe it's the CERNA declaration filed on Tuesday or so. I don't recall the specific numbers, but it is in the record.
Are we 100? I'm sorry, I looked at
My
it.
recollection is it's in around 300 or so.
300. Is every one of them in the same jurisdiction in Texas?
Your Honor, I don't know that question.
They don't either. Hard to file. The other thing I just wanted to clarify is, it seems like you're sort of both crossing over here. The written TRO doesn't say anything about bringing airplanes back. It just says that you shall not remove people that are within the class. But it was in his oral direction, which you say was not, I've misunderstood the position. My understanding from government's position in district court is that was not a binding order until it was reduced to writing. And so when you're asking us to vacate TRO, are you asking us to vacate the written TRO, which is one that you say is legally operative?
That is what we are asking this court to stay or dissolve. But certainly, I think plaintiffs are taking the position that that incorporates more than what is it within the four
But you're
corners
not.
of its writing.
Right, but you're.
We take a contrary position, but jurisdiction in no way depends on the merits, as the Supreme Court has repeatedly explained.
Okay.
Right, you want to wind it up?
Yeah, very quickly, Your Honors. On the habeas point, you've heard that it could be brought in habeas. Review means that it needs to be so. We've also heard from opposing counsel right now that they intend to bring evidence of individual cases. I think that's important for two reasons. It is in severe tension with commonality requirement of a class. They're now getting into very fact-bound characteristics that are inconsistent with class adjudication. And I think it just, again, underscores how much this is sounding in habeas. My particular circumstances warrant you not exercising custody over me is a classic habeas claim, and it should be brought as such.
Right, thank you.
Thank you, Your Honors.
Honorable Court now shall adjourn until Tuesday, April 1st at 1:30 a.m.
So, okay, so just for this court case, there are some lawyers that basically brought, they're representing 5 people who are potentially, I don't believe, or they might all be in custody, but they haven't been deported yet, who are Venezuelan immigrants who are worried about being deported. And they filed a court case, and then as part of the court case, they filed a preliminary injunction and a temporary restraining order, basically saying, hey, before this court case is even started, could we please not allow the government to do this because our clients are going to get fucked. Okay, they're going to be shipped up to some El Salvadorian prison and we'll never get them back. And so the judiciary said, yes, this is fine. It's filed in a district court in DC, the district court in DC. I believe there's only one in DC. And then the government is now arguing that this TRO should be lifted. Typically, you don't even appeal TROs, but I guess we are now. So the government's argument, this is the thing that I guess you need to understand is just because it's so crazy. The government's argument is the following. The government says that because the president's wartime powers are so expansive, the president should never have to justify who qualifies for the Alien Enemy Act. The government doesn't have to prove that to anybody, doesn't have to show evidence to anybody for that. And the decisions that the president makes when it comes to deporting aliens under the Aliens Enemy Act should be judicially unreviewable. Not only that, if you did want to file something, I guess, to fight it, if you wanted to do it, then maybe you could file a court case if you wanted to challenge this. So affirmatively, you're not given any kind of due process. But if you wanted to file a writ of habeas corpus, so filing something in a court saying, hey, I demand to have some process or procedure or whatever, now you have to file for it, right? They're saying that if you want to do that, then you're allowed to do that, fine. But the challenge is the government is not putting people on notice, telling them that they're going to be arrested and deported. And not only that, the government is shuffling people around random federal districts when it comes to imprisoning them. So the lawyers don't even know where the fuck their clients are. No one knows. So, and the end of this argument is, and these aren't like, is this the worst case scenario or is this an assumption? Like the guy said it here, the lawyer for the government here literally said, we do not have an affirmative responsibility, meaning with no notice, we don't have the obligation to tell anybody when we're coming to arrest them. And we don't have the obligation to tell anybody where they're being held. So the government is basically saying, if you really want to challenge your detainment, then fine, you're free to do that. But we're not going to tell you when we're coming for you. We're not going to tell you when we're shipping you out. And we're not going to tell anybody where you're being held. And also, when you file your writ of habeas corpus, you have to file into the right district. So the lawyer that you might not even have in time because you don't even know you're going to be arrested, the lawyer needs to know where to file that writ at, even though he doesn't know where you're being held, and the government's not going to tell anybody. It's just like an unbelievable. It's as evil as it sounds. It's just an insane set of circumstances. Yeah.